Mirrors, may I make a request to your lordships? Mirrors, request was to consider to list Mirrors a commercial appeal, Mirrors, in
Yes.
the entry lordship court yesterday, a 37 commercial appeal. Honorable Court has kept it in the month of June. We had not pointed out that execution proceedings have begun. It was yesterday before the court concerned. It is kept today.
Your voice is not that clear. So
I'm sorry.
It was
I'm sorry.
yesterday. It was posted.
Yes, my lords. The Honorable Court was requested yesterday to list a commercial appeal. The
Yes.
matter is kept in June by your lordship bench. I wanted an early date because execution has commenced in the executing court.
It
was
already
yesterday
adjourned.
in the executing court. It is kept today by the executing court, and no adjournment is granted. So request
You are on
was to
record
consider.
in this matter. So it is adjourned to which date?
Because as of now, it's adjourned to 23rd
June
June.
26.
23/6.
So now which date do you have to? If it is date is already given, you have to file IA, Mr.
No, my lord, sir,
Counsel.
it's not. It was mentioned some fresh matter.
But if date is already given, then formal IA may be filed. We'll prepone it.
Very well, sir. As you lordship feel appropriate.
That is the practice. Yes.
Very well.
It was not listed.
No.
Then it is. Then it is.
Only
all right.
mention
When
was.
do you want?
Only mention was. I would
25th.
request for this Friday, my lords, if my lords feel appropriate.
Pardon. 25th.
What should
do.
be considered?
25th will do. All right.
Yes, my lords. My lords, yes, it's do, my lords. It's fine, my lords.
Yes. 25th.
Much obliged. Grateful to your lordships. Grateful.
My lord, there is
Yes.
urgency in the matter. This may kindly posted for tomorrow, my lord. Tomorrow, because urgency is that, my lord. This some petitioners applied for the posting, and they were issued provisional appointment order. And the bank said that you go get the original for verification with the copies you already submitted. And now they have come before the court stating that the original which we brought, that original records are not returned. But the bank says that because as per the procedure, it has to be returned. Now this learned single judge said that you file a complaint to the police. And that accordingly, those people who filed the complaint, and with the help of the unions and all, that learned single judge specifically said concerned officials will be called for an inquiry. But they have issued the notice to the MD and CEO and called him for the inquiry. And this may be kindly taken up.
There is no urgency. There is no urgency.
No, my lord. Tomorrow this matter that MD is called on 24th, 25th. He has to come.
Who?
For the police.
Who?
That managing director and CEO.
What
Because
we
he is not the official, my lord. That learned signature charge is very clear. The concerned official may be called for interrogation. Now they have issued the notice, my lord. This may kindly be taken up, my lord.
For
Because
that, no urgency.
that is very.
No. Somebody has to go to police is no urgency. Listing.
No, my lord. In this case, as per the orders of the single judge, clearly mentioned. Concerned officials may be called. But those people, instead of calling the officials, they are issuing summons to MD and CEO. And he is no way concerned because it is matter pertaining to some other.
26. 26.
Well, after lapse of 40 years, they obtained the kata on the order of the assistant commissioner.
No urgency. No urgency.
Blue gum trees are there, madam. They're trying to cut the trees, my lord.
Yes.
Yesterday, my colleague has been moved. It has been given on 24/6 before vacation, any date, my lord.
Not
because they're trying to interfere and the blue gum trees are there.
9th June. 9th June.
Tomorrow, before vacation, any possible because
not
already
possible.
obtained the records.
Simply not possible.
With your lordship's kind leave, my lord.
Yes, Mr.
My lord, the lake matter, my lord. Any date convenient to your lordship, we are pleased to hear the lake pertaining to any date convenient to your lordship, depending on your lordship's board, can be given, my lord.
2 days listed. It is going to be listed tomorrow, probably.
Please,
Lake
tomorrow.
matter is going to be listed tomorrow.
Can I request for day after, if I'm not in station tomorrow, my lord? I'm sorry, my lord. Your lordship.
That is my impression. It's going to be listed tomorrow. Some Wednesday was there. Tomorrow is Wednesday. If it is listed tomorrow, we'll keep it day after tomorrow.
Please, I'll grateful to my lord. Kindly. Grateful.
But it is already heard and released, Mr.
Heard and released, my lord.
Heard and released only to see that it comes before the same bench.
Please. Oh,
Because
please.
we have invested time and you have also invested energy.
Yes, a lot of time, my lord, has been spent.
Your Lordship's kind permission.
Grateful to my
Serial
lord.
number 80. Last week I filed my objections, my lord. Office objection is there. That I have not filed the, serving the copy, that acknowledgement I have not filed. I have informed the other side also.
Lake matter.
Serial number 80. I filed my objections last week. WhatsApp I have served. That physical filing I have to file in the counter. That is the
Serial
option.
number
80.
180.
80, my lord.
I have served a copy on my learned counsel. I have informed him also. Physically also I have served him.
So what do you want?
No, I will comply with that. Kindly.
There is nothing to be complied with. Only arguments are to be complied with. You comply with making arguments. There is nothing to be complied with.
Kindly one short date to be given. I filed last week on the objection.
Nothing to be complied with. We remain present when it is
Serial number 42, my lord.
42.
I apply for appellants.
Yes.
Seek for short accommodation.
42 you want time. All right. After vacation.
Please, my lord.
17th of June.
Interim order to be extended. my lord. Interim order to be extended.
Interim order shall stand next time.
Grateful, my lord.
Lordship, that the petitioner is the owner of Sri Pawan Sports and Recreation Club.
Till the next date.
And the Tumkur Police Kurigal, they are instructing him from doing his business by advertising his properties. So, criminal, they are not following the orders of this honorable court. Hence, criminal
After vacation. 9th of June.
9th.
May I please, Your Lordship?
Serial number 58, my lord.
58.
For the respondents, my lord. My lord, to file affidavit, a short accommodation may be granted. Complaints affidavit to be filed, my lord.
Beyond vacation. At the request of learned compliance, stand over to 27th June. Yes.
May I please, Your Lordship?
Serial number 8 for petitioner.
8.
8. Kindly have it after vacation, your lord.
After vacation, as requested by learned for the petitioner, stand over to 9th July.
Get.
Limit of submission. Serial number 39. In 8, sorry to interrupt. In 8, there is a punitive order. The objections are not complied. 8. Just now there is sought an adjournment. There is a punitive order of the court. The objections are not complied within the specified time. It automatically stands dismissed. That was what was mine.
There is no objection. There is no objection.
8. I'm sorry, madam. I'm sorry.
Serial number 39, madam.
Serial number?
39.
39.
Short adjournment.
The request of learned appellant,
Connected matter. I'm for the contempt.
comma, as paid for, comma, stand over to. It will go in July now, 16th July.
This is first matter regarding the denial of justice by the state, since I request you to take up the matter, I have filed the,
Has he got the certificate under the?
no, I have filed the writ petition on 1st March.
No, whether he has got certificate. I will not give the audience. Ask him.
May I please, Your Lordship? Serial number 27, my lord.
Serial number?
I'm for the respondent. In serial number 27, I'm for the respondent for 6. I need to file objection. The short accommodation may be granted, my lord.
17th of July, as requested by learned for the petition.
File is not being sent to the party in process committee for issuing forms, hence
He has to obtain. Then mention after that.
they are not sending it to them.
Then ask some your lawyer to mention. We are not giving any audience to any party in person unless you are holding certificate. Yes.
Serial number 70.
No.
Serial number 72, my lord. I am for the petitioner in this case.
70. 72.
72, my lords. Await service of notice to LRs, my lords. Kindly grant 2 weeks time, my lords.
At the request of learned petitioner, as paid for, stand over to 19th of July, 21st of July.
Your Lordship, serial number 18, I request that it may be posted on the 29th because connected matters, I request it may be posted on 29th because connected matters between same parties is listed on the same day before this court.
18.
1-8, Your Lordship.
Since it was stated by learned advocate Miss
Petitioners. Diksha Garg.
Diksha for the petitioner, since the similar petition is slated to be listed on 29th.
Please, Your Lordship.
29th of April. Come on, the present petitions will also be listed on 29th.
Much obliged.
Any other mentioning? Contempt matters, seal number 1. Mr. Siddhamalappa PM.
Petition. Well, it's in this matter. The SLP was filed before the Honorable Supreme Court, my lords. Regarding that, I'll seek instruction and I'll file a better affidavit, my lord, regarding delay in filing the contempt petition.
What SLP?
On the judgment and decree passed by the Honorable Division Bench, my lords, the respondents had.
That will not extend the time. All like after 22nd July.
Obliged, Your Honor.
Seal number 2. Mr. Rajendra, yes.
Going for the complainant, my lords. My lords, the present contempt is arising out of the order passed by the joint single judge, my lord, wherein a direction was issued to the accused. The accused was arrayed as respondent number 3, my lords. The order, my lords, is at Annexure A, my lords, page number 15. The accused was arrayed as respondent number 3, my lords. At page number 20, my lords, if your lordship may allow me, my lords.
Notice returnable on 1st July.
Seal number 3. Chidambara GS. Seal number 3.
You are in number 3.
Seal number 3.
Right.
Page 16 is the time limit. Page 16 is the time limit.
Page 26.
Page 14 is the order, 13 is the order. Page 16 is the direction. The direction to pass an award within 3 months.
Notice returnable on 10th of June. 10th June.
There is. Complainant. Status quo order is 11/12/2023 is violated by accused number 3. In page number operative question 15, but status quo order has been violated by the accused number 1 to 5 by of cutting the trees and burn the trees. Status quo order is in operation till today, Maharashtra. The cut and burn the several trees standing
Which
in the land
order?
in question, Maharashtra.
Which order you are complaining of?
In page number 15, Maharashtra.
15.
Operative question. In page number 13, status quo order. Operative question is last page 15 minutes. What is the directive to maintain status quo, Maharashtra? Case is pending.
So firstly it is interim order, secondly it is barred by section 20 of.
In 18.6 also, thereafter also, 18.6 also cut and burn the trees. Kindly see the ink page number, Maharashtra. Ink page number 29, Maharashtra. And 22/6/2024. That continuously violating the sound report order. Kindly see the ink page number 29, annexure happened, Maharashtra. And 22/6/2024 also, they cut and burn the several trees. Produce the photocopy of this. Cut and burn the trees. Kindly see the ink page number 29, Maharashtra. So status quo order is still today in operation.
Or learned advocate Mr. So-and-so for the petitioner as complainant. In the facts of the case, there are two clear reasons why this court would not be entertaining the present contempt petition. Firstly, the order complained of for its breach is dated 11/12/2023. The contempt petition is filed on 15/4/2025, which is evidently beyond 1 year. Full stop. Section 20 of the Contempt of Court Act, paragraph reads as under after Code Section 20. In view of the above statutory provision in the Act, the contempt action in contempt could be initiated only within 1 year from the date of cause of action, that is when the contempt can be said to have been committed. The petition is barred by above embargo of time. In the second place, the order is admittedly an interim order passed in the pending writ petition number 16708 of 2021. Learned single judge has directed the parties to maintain status quo, which is the extension of interim order which was passed by the land tribunal, the judgment of which has been challenged before learned single judge. Full stop. For the aforesaid two reasons, independent in themselves, the contempt petition is since the order is interim order, no rights are finally crystallized for any of the parties. Full stop. It will be open for the parties, open for the petitioner to work out his rights and remedies in the proceedings of writ petition before the court concerned. And in light of the two above independent reasons, two reasons which are independent in themselves, the court is not persuaded to entertain the contempt petition. It is dismissed. It is accordingly dismissed.
Number 5, Mr. Ajesh Kumar.
Hello for the petitioner. This reference to the solid waste management public interest litigation. The BBMP was supposed to file a report, my lord, as per the last order dated 16th.
BBMP has to file. I am appearing for pollution control board, my lord.
Wait for the keep that.
Seal number 6, Sumoto PL.
Lord, I appear as a Micus, my lord.
Yes.
My lords, I have gone through the reports which have been filed by the government, my lords. There are two reports. One is of February 2024, my lords. And thereafter, since your lordships raised certain concerns, another affidavit after spot visits extensively has also been filed in November of 2024, my lords. I only wish to highlight two aspects, my lords. Perhaps with that, it may be disposal. One is, if your lordships were to kindly take the report of February 2024. This is relating to the hostels for the social welfare department.
Yes. Yes.
Am I audible, madam?
Yes, you're audible, not visible. Yes. Yes. You can proceed. Yes.
Well, please, madam. Please. Yes. Kindly see the report of 2nd February 2024 at page 4. One of is regarding the strength of the team, my lords, which takes care of these hostels. That is the senior wardens, junior wardens, and the cooks, my lord.
Which is the date of the
Only
report?
2 paragraphs I wish to.
Which is the date of the report?
My lords, 2nd February 2024, 2/2/24.
24.
24, last year, my lords. In that, I wish to take your lordships to page 4. Does your lordship get the report, my lord?
No. The first is of
2/2/24.
No, 18/7/24 is there.
My lords, there is one report which says submission of report as per direction from the Honorable High Court in writ petition, Office of the Commissioner, Social Welfare Department, dated 2nd February 2024, my lords. This was served to me by the government. Maybe, please, it may have been served, my lords. I don't have the memo facing sheet, only the report I have. In that report, in that memo, it's annexed with the report of 2/2/24.
Correct.
Please, lords, that in that your lordships may kindly come to page 4. 4 and 5. If I may read, my lord.
Yes.
Overall, your lordships get that.
Hmm.
Overall, against the sanctioned warden, senior warden posts, 548 posts are presently vacant posts. Out of these 548 vacant posts, 42 warden posts are being under process for appointments. Out of 506 warden posts to fill 232 warden posts, proposal dated 23/8/23 sent to Finance Department for concurrence to fill through KPSC. A copy of the proposal dated 23/8/2023 is herewith produced and marked as annexure so and so. In remaining 274 warden vacant posts, 256 are promotional quota posts, 18 direct recruitment warden posts have newly arisen, and the proposal will be sent to government to fill up these posts as well. Further steps will be taken to give independent charge to 465 junior wardens to the hostels wherever it is necessary for smooth functioning of the hostels. The department has taken steps to fill up the vacant posts in the department time to time as per the cadre and recruitment rules. Further steps will be taken to give independent charge to 465 junior wardens. Lords, my only submission in this regard is the finance department was specifically made a party in this during the course of the proceedings. We do not know the status of any progress having happened in the last 1 year. So my request would be, if any specific direction is issued in disposal, that within a time frame, these filling up of the posts have to be made. That would address one of the concerns, my lord, so far as the managerial staff being available is concerned. That would be my first request, my lord. That a timeline, according to their own report, there are gaps, there are posts which are vacant. These need to be filled within a timeline. What is the timeline that either they voluntarily mention, or more preferably, my lords, your lordship would give them a time frame within which these have to be filled up, because it is linked with the rights of the children who appear in the in these hostels, my lords, the young adults. The second aspect is the report of 2024. If your lordships were to take that report, this is an affidavit filed by the joint director of the department, the commissioner of social welfare.
Yes.
In this, they have given details about the infrastructure development that has happened or the inadequacies that are there. Lords, these are factual inquiries. This honorable court in a PIL or as amicus, I may not be able to verify the authenticity. Considering these at face value, my lords, my humble request would be, let the head of the department, who is the commissioner of social welfare, be asked to oversee within again a time that the inadequacies mentioned in the report in these districts are addressed within that timeline. These are the only two things which survive after these reports have been filed. One is regarding filling up the posts, timeline for that. And
what are the inadequacies? This is stated in the affidavit.
yes, my lord. Yes, my lord.
Infrastructure.
It is not strict. Your lordships would find it.
Creation of new hostels.
They have given. Yes, my lords. This is not something which would happen with one direction, my lords, but they would require a timeline. And definitely oversight by some higher official being pinned with the responsibility to address this within a reasonable time frame. This side, the concern of the Suamoto petition, my lords, may be addressed to a substantial extent. They have given details about what category of hostels, what are the infrastructure facilities that are needed, as well as the steps which are taken. An oversight may be needed. Para 15, para 16 of this report.
So about first filling up of vacancies, what time?
Yes, my lords. If the government has something in mind,
we are asking government only. Yes.
Please, please, please.
That appears to be justified because merely sitting tight will not do. We say 6 months. 6 months.
My lord, if I may make one short submission, my lord. This is relating to the interdepartmental issue, my lords. One of the things that has happened here is, as always needed in all governments, the approval has to come from the finance department. But one important aspect is, these are not approval for any supernumerary posts or over and above the C&R rules. Whatever legally vacant posts are there, as per the C&R rules, to fill up that, finance department's nominal formal approval is needed. The finance department cannot say we have budgetary constraints, therefore we will look into it and sit on it forever. That is my humble submission. They cannot take that stand. That is the reason why finance department was specifically made a party as well. If it were creation of new posts, then of course they can talk of budgetary constraints. So whatever timeline is fixed by this honorable court.
Would you prefer to file memo indicating 6 months, memo or affidavit, whatever?
My lord, the officer concerned is present before my lord. If my lord wants me to file a memo,
in your interest.
Please.
then I'll make a request.
An affidavit by the commissioner, my lords, of the social welfare.
Some responsible authority.
Very well. My
Please.
lord may have it on Monday, my lord. I'll file.
Yes.
Monday at 11. Both ways, the other also making up the deficiencies about the
deficiencies.
There you can take
Please.
little more time if construction is to be done.
Please.
So what is stated in the first affidavit of February 24 and subsequently in the second affidavit of
November. Please.
So both you indicate the broad timeline and will conclude the matter.
Well.
So at 11 on 28.
Please. 28. Grateful.
Yes.
Commissioner.
This is seal number 7.
I appear for the petitioner.
For respondent number 3, my lord. Kindly seek for a passover, my lord.
This is with regard to, my lord, the work boards being authorized to register the marriages. The state, my lord, has to complete its pleadings.
Not done.
Not done, my lord.
My lord, I seek
state
for
is
some
allocated.
time in this matter. I have some difficulty, my lord. Immediately on reopening, my lord may have this. I'll make a submission, my lord.
And even work board also, my lord, sought time to file additional statement of objections in addition to whatever they have filed and placed on record.
We have to be little stricter. This petition was filed as back as on 12/7/24 as public interest petition. It raises an important issue regarding the power and authority on part of the Waqf board to recognize the marriages in the community and the marriage certificates. After hearing the parties, including learned additional government advocate, an order was passed on 21/11/2024. A strong prima facie case was noticed and impugned order dated 30th/8/2023 authorizing the Waqf board and its officers to issue the marriage certificates in the state was put in abeyance. Full stop. The Waqf board and its officers were directed not to issue the marriage certificates till the next date. Full stop. Despite the record bears out that the petition has been adjourned from time to time only on the ground that the reply affidavit is not filed by the state. Full stop. Today also, learned additional government advocate Srimati Nilofer Akbar raised for time for the very purpose. So, which order was passed? Order was passed on not on 19/3/25, passed on 21/11/24. I say 21/24. It is to be noted as unfortunate. It is to be observed to be unfortunate that the respondent state has not been responsive in filing the affidavit reply to this public interest petition, which has public interest petition, despite time is given more than 3 occasions. So, with the last chance, in that view, no further time could be given to the state to file the reply except up to 9th of June. Full stop. The petition shall be listed on
For final disposal, your lordship.
On 10th of June, on 11th of June. Full stop.
My lord, in the meanwhile, my lord, they have not furnished me the
amended copy of the writ
In the-
petition.
In the facts of the case, the interim order passed on 21/11/2024 shall continue to operate till further orders.
Obliged, my lord.
Who are you, madam?
Third respondent.
Third
Respondent. Board.
The Waqf board.
Waqf board.
Party in person.
Waqf board.
Waqf board, my lord.
You are a lawyer. So you also file reply if you want to file. Or you have filed, already filed. Have you filed your reply?
Yes, my lord, I have.
Statement
You have.
of objections.
You also filed it.
No, she's representing.
With you.
So 8 is adjourned. So writ appeal matters, seal number 9, Mr. Gaurav GK.
Keep
Lord, there's a delay, my lord, in this, all these matters, my lord.
today.
Delay is there.
Today we'll keep back, then we'll take.
Very well.
Putting 10, Mr. Gaurav GK.
Keep back.
Seal number 11, Mr. Regde Shripad.
The appellants in this case. The another writ appeal arising out of the same order is also pending. Is filed by respondent number 4 and 5. That is writ appeal number 1930/2024 arising out of the same subject matter. If it is taken up together because the grievances are same in the both the writ appeals.
What is it?
This is, my lord, with regard to the disbursement of compensation made by the land acquisition officer under the acquired under the KID Act. The compensation was disbursed to the appellants and respondent number 4 and 5. And thereafter, the cousin sisters, they filed a writ petition challenging that their application was pending. During the pendency of their application also claimed this amount, releasing of amount is incorrect. Hence, cash the award and the payment of compensation was by the land acquisition officer. Then the learned, before the learned single judge, since it was a family dispute, the learned judge suggested, why can't you sit about and settle the matter between themselves. Then after discussion, they agreed for redepositing a sum of rupees. Can you see in the order at page?
I represent
22.
Respondent 6 to 8. Not the appellant hearing misleading the land acquisition officer without disclosing the respondent 6 to 8 or the LRs. They have misrepresented and obtained a consent award in respect of 2 acres of land. And the award amount is 2.20 crores, my lord. And before the learned single judge, my lord, we have filed an writ petition that was allowed. And there they have filed a memo also agreeing to redeposit whatever the amount availed by the KID.
Producing. Not about the share.
That is the order passed.
Their share.
In the impugned order.
Page number 22.
That we have seen, but you said that they had filed this very petition.
Yes, very petition. They have consented for the redepositing the same. Therefore, the award was set aside.
Where is that recorded that they have consented?
No, let's say page number 22, Lordship, may kindly see para number 6, my lord.
Lord, para 9.
Yes, agreed that this will redeposit. 6.
Yes.
It is also submitted by the learned counsel that in view of this discussion held with the petitioners, the respondents have agreed that they shall redeposit the sum of rupees 26,35,416 within 2 weeks from today towards the alleged share of the petition.
Para 9.
Therefore, the matter be referred to civil court for further determination of the matter. The submission made by next, my lord, made by Shri P. N. Manmohan, learned counsel appearing for the respondent number 4 and 5, that the respondent number 4 and 5 have compromised with the petitioners insofar as disbursement of amount is concerned. Accordingly, sought for bifurcation of the award amount to the payable to the petitioner, and therefore sought for disposal of the petition. P.V. Chandrasekhar, learned counsel appearing for the respondents KIADB, submitted that the compensation has been disbursed in favor of private respondents 4 to 7 in terms of award dated 9/11/23. And further, he submitted that as the respondents KIADB has to pay approximately 39,96,200 to the petitioners as well as the respondents number 4 and 5.
The original petition.
Which is the balance.
Your original petitioners.
Yes.
Their petitioners. What had happened, Madam, may I submit, my lord, because it is a family matter, court suggested us, my lord, we shared together and then towards their share, petitioner's share, it comes about to 26,35,416 out of the amount received by the these appellants. And another amount of rupees 39 lakhs, I'll submit, 39 lakhs 96 sorry, not 39 lakhs, the respondent number 4 and 7 have also admitted. Sorry, for 4 and 5 are submitted, they will also redeposit the amount due by them, I mean, towards their petitioner's share. Then accordingly, a memo came to be filed. The learned judge suggested to file a memo. We filed a memo also, my lord. Then the learned judge, instead of permitting us to redeposit that amount, entire amount is to be redeposited and then matter is to be referred to section 30. That is what, my lord, being agreed by this, the appellants have filed this. Even now, we are ready to pay this much amount, that is the petitioner's shares. Out of the amount compensation they have received, their alleged share, we will redeposit it in the KIADB.
The entire amount has to be redeposited.
All our my lord persons they have received and they have certain amount has been appropriated towards their family needs and all. Now recover that amount from them and all redeposit the entire amount would be very create very hardship and difficulty for the appellants also. Insofar as their share is concerned, they are even now they are ready to redeposit money, provided a week's time or 2 weeks time is given if my land friendly agreement. That's the only grievance in this petition, writ appeal, my lord.
The appellants are well aware. We are the legal heirs of the owner. Suppressing that fact, Lord, they have obtained consent award. Now, when we filed the writ petition, they agreed to redeposit everything. Now, the amount has to be apportioned. Even KIADB is due to pay rupees 39,96,200. Therefore, the question of their portion, my portion depositing before the land acquisition officer does not arise. Since the entire award has been set aside, they have to redeposit the entire amount.
Lord, this is the compromise which was our main writ petition. We did not argue even matter, my lord, on the basis of compromise that is held between the discussion held between the petitioners and these appellants.
No, you are required to redeposit how much amount?
Pardon?
You are required to redeposit how much amount?
My lord, as per the order, entire to 1 crore 58 lakhs and also.
Where is that?
My lord, this order says, my lord, the of course amount is not said. If this is the amount I have to deposit, I will certainly deposit within a week's time, my lord, even now, my lord, because the time was.
In consent award 9/11/23.
9/11/23.
1 crore.
2 crore 20 lakhs.
It was apportioned between respondent appellants and respondent number 4 and 5.
Where is that?
Annexure A, please. Annexure A operative portion is at not the translation. Page number 53, internal page number 12. Order. It is hereby ordered to pay compensation of rupees 1.10 crores per acre, as per agreed rates under section 29(2) of the KIADB Act 1966 in respect of the land of old survey number 66, new survey number 66/3 as mutation to the Caste, 35 guntas and survey number 221, 2 acres extent, so and so village. This was granted only in respect of 2 persons.
Appellants and respondent 4 and 5.
No, this award. There we were not made party.
No, what I submitted, my lord, the their grievance as per the genealogical history submitted by them, they have got share of 1/6 or so, and that amount will redeposit so that issue could be resolved immediately, I mean, amicably. That's the reason my lord filed, my lord.
in civil court. They are admitting the fact that they are entitled to compensation. They are entitled to share in the law. Share is the matter to their entitlement is not in dispute. That is perfectly all right. This order is nothing wrong in this.
In submission, my lord, this is what has happened, my lord, I may say.
Therefore, their determination you go by civil court.
No, determination is, my lord, I will repeat this as a family settled, discussion, it has, this memo was filed. We have not argued the case also on merit, my lord. That the merit, we have filed a detailed statement of objection. There was a partition that was between the fathers of respondents, appellants and respondent number 6 to 8. Then 6 to 8, yes. My lord, there, in the partition, they have separately apportioned their land also. And the land, actually, they were not entitled. Any compensation, that is the statement of objection that was filed. And we could not address the argument on that because the my lord, because there is a reason behind that is because settlement took place between the parties, as per which memo was filed, my lord. Hence, now I could not address my argument also on that point with regard to the whether the petitioner, petitioners, the writ petitioner are really entitled to share. But they are cousin sisters, they are claiming. Then amicably we wanted to put an end to this dispute, and so that without this thing, they are ready to deposit their towards their share as such concern. If you are given if the memo is rejected, then certainly I would argue the merit on merit also, my lord. I could not address the argument, matter on my argument, merit also, whether they are entitled or not, because prima facie they have to make out a case. Unless the prima facie is made out, that's because they are claimants.
So heard learned advocate Mr. Hegde.
Yes, yes,
Hegde for the petitioner. Learned who appears? Additional government advocate. Mr. Harish for
one make me submission, my lord.
Respondent state and authorities and learned advocate SS Mahendra.
For 6 to 8. 6 to 8.
Respondent 6 to 8 original petitioners who appeared upon service of copy of the appeal in advance.
One submission, my lord, just may be permitted to make, my lord. Now, the question is, my lord, with regard to once the award is set aside. Now, as per law, also separate award has to be passed. There is no provision to make separate award also here in this order. Learned single judge order. Deposit the entire amount to the KIDB, under section 3031 reference. Without an award is there is some technical flaw also, my lord, because the land acquisition officer cannot deposit like that unless there is an award. If the award is set aside once, there must be an award once again, either a consent or general award or whatever it may be. There is no provision in the order also for that. Direct the amount to be deposited is, my lord, it will create problem also again for the land acquisition officer also. That's the reason we put an end to this, my lord, their agreeable share, eligible share according to their claim. We said we ready to redeposit, for which the petitioner did not raise any objections, even in the writ petition proceedings also.
Dismissed. Okay. Dictated in the chamber. Yes.
Seal number 12 to Millie.
Lords, this matter, my lords, I apologize, my lords. Today, my senior, there's some personal inconvenience for my senior, my lords. Would my lords consider having it any other day, my lords?
Every time, same statement.
I apologize, my lords. Today, there is some personal inconvenience. That is the only reason why I'm asking for a adjournment.
After vacation.
Very obliged.
18th of June.
My lord, may I request, my lord, there can be a stay on the order.
Lords.
Stay. I have filed an application because it's going too long a time. If
will
you
not
file the execution petition,
They will not do anything.
Okay.
Don't do anything since you are seeking time. Shall we record that?
My lords, I'll file the objections to the application also.
Since you are seeking time, till next date, don't precipitate the thing.
Lords, there's no operative order, my lords. No direction. Only direction.
What is your apprehension?
Direction to the appellant.
He may
my lords.
file execution petition. That is the only management.
Not
The
filed.
execution cannot be filed.
If filed, you are at liberty to stand at the request of learned advocate Mr. So-and-so on the ground that the learned senior advocate is not available for conducting the matter due to personal difficulty, the appeal shall stand over to 18th of June full stop, learned advocate, paragraph. Mr. Senior Advocate, Mr. So for the appellant expresses apprehension that in the meantime, the steps may be taken by the respondents to bring out an irreversible situation for the appellants, full stop. If any such developments, including the filing of execution take place,
cannot be filed.
comma, the appellants are at liberty to file the interim application for appropriate interim orders even during the vacation.
Please. Obliged.
Much.
Seal number 13, Mr. Sunil Kumar H.
Delay.
Please, my lord, delays the
Notice returnable on 19th of June.
Lord, in this matter, Lordship may kindly dispense the notice to respondent number 35, my lord, because respondent number 16 and 35 are one and the same. It's wrongly printed.
Except to,
35.
except to,
And serial number 15 also same, my lord. Sorry.
so write down in this seal number 12. Seal number 13. Notice to the respondents except reason number
35, my lord.
35 returnable on 19th June.
Serial number 15 also same matter, my lord, the same parties.
15 also same order.
And in that respondent 34, my lord, that's all.
No notice to 30.
Please, obliged.
So, seal number 14, Mr. Ravi Shankar.
The dispute between father and son.
Notice returnable. Delay.
No, I'm just almost requesting my lord to close the matter for this reason. Dispute between the father and son. His father gave a site and also about 15 lakhs of rupees to the son to create a Vishwakarma Brahmin trust. The son did not do so. So he went to the AC court. AC court cancelled the gift deed. Matter got reversed even by the learned single judge. Now the son became a father became almost a destitute. In fact, the learned judge in the Chikmagalur town, he saw some old man on the road. So he hospitalized him, gave him, and the legal services authority now have filed a suit for cancellation of the gift deed. So I no longer have anything because I'm challenging the same thing here. And now the father has already gone to the civil court and he has sought for cancellation. I'm only requesting my lords to see that these orders should not get influenced by the learned civil judge there who is now adjudicating the matter. My father, I appear for the father. He's an 85-year-old man. He's become a destitute. Son has taken the property and the money has left him in lurch.
While this appeal comes up for admission, along with the application for conversion and delay of 106 days, in course of the submissions, learned senior advocate, Mr. So and so, with learned advocate so and so stated that the substratum of the subject matter of the appeal is dispute between the father and son. It was stated, paragraph, it was further stated that the father has instituted a civil suit in relation to subject matter and the same is pending. In that view, it was fairly stated from the present proceedings of the appeal may not be pursued by the appellant as the appellant is already in capacity of plaintiff seeking his rights in the civil suits.
Yes.
Full stop. As requested by learned the appellant, the delay condonation application as well the appeal both are disposed of as not prosecuted any of the pendency of the suits. Full stop. Both are disposed of, however, with an observation that the civil suit which is instituted by the appellant father shall proceed on its independent merits without being influenced by the great order passed by learned and shall be decided on the basis of the evidence which may be led by the parties.
Great.
15 urgent, seal number 16.
Appeal and the application both are disposed of in the above terms.
Before respondent number
16.
4, Your Lordship.
Mr. Raghavendra.
Kindly pass our Lordship.
This was which number? 14 is over. Now,
My lords, in this matter, I'm for appellant, my lords.
Kindly pass, Your Lordship. We will hear the matter.
pass over is not possible after vacation. Any urgency?
Urgency is there, my lords,
With the-
because, my lords, the respondent has filed a suit for off share in respect of certain lands, my lords. Those lands have been acquired, my lords. My lords have filed a representation before the KDB for release of undisputed off share in my favor, my lords. I have also filed a writ petition to consider my representation. The writ petition was allowed. Again, the respondent has filed another writ petition and get it set aside, saying that there is a suit pending before the civil court, my lords. Now, in the civil court, he has also filed an application for seeking not to disburse the amount in my favor, my lords. Insofar as off share is concerned, there is no dispute at all. The amount may be released in my favor. In the meantime, during the pendency of the suit, he has filed many applications for amendment and impleading the proposed defendants, my lords. Thereby, there is that it is causing a lot of delay in getting the amount released, my lords.
What is the difficulty?
My lords.
What is the difficulty? What is the difficulty?
My lords, insofar as half share is concerned, there
We
is
do
no
not-
dispute.
There is nothing like half share here.
My lords, they have sought for
Your
only.
Lordship. It's a matter of trial, whether the property is joint family property or self-acquired property.
In the partition suit,
Moreover, they are not made part in the writ petition, Your Lordship. And they obtained order behind our back, Your Lordship.
So suit is pending, your disbursement application is pending, everything is pending.
my lords, there is an application pending before the civil court.
Then
A direction may be issued to the trial court.
it is already there.
No, time-bound direction is not there, my
One
lords.
single judge has already said that same shall be considered in accordance with law, that application.
But they have filed two applications for amendment and all, my lords. It is causing delay, my lords.
It is your business.
A time limit may be fixed for disposing.
Dismissed.
Much obliged.
This. So number 17, Mr. K.S. Ponnappa.
My lords, in this matter, my lords, the reservation to the allocation of the post of the president of Madikeri CMC is being questioned. For the past 6 terms, my lord, the seat of the president has been reserved for general women, which is against section 42 of the Karnataka Municipalities Act and also against the directions passed by the Honorable Supreme Court, which I have attached at annexure C at page 50, my lords. Page 50 is a relevant portion of the order of the Honorable Supreme Court, my lords. Despite following the above mentioned steps, if the software either encounters a repetition or exceeds the quantum of reservation or finds the final outcome to be in breach of section 42A, such residual office shall be interchanged with general category or any other category without affecting the principles of rotation. All that I'm seeking, my lord, since it is general women for the past 6 terms, it may be made general as per the directions of the Honorable Supreme Court.
Notice written, 23rd of July.
My lords, elections are imminent, my lords, on the 28th.
Election can't be stayed.
Well, if the state government is to concede saying there's been a mistake, because it will become infructuous by 23rd. That's why.
Interim stay cannot be granted. When elections are going to be held?
My lords?
Elections are going to be held.
Eminent, my lords. 28th of this month.
Then there is no.
There is a
future purpose if you succeed.
No, my lords, only on 3 grounds, my lords, for 6 consecutive
Not
terms.
possible to stay the election. It can't be stayed.
My lords, at least the state government can rectify this if they are magnanimous enough to say that this is in violation of the Supreme Court order and also against the statute.
What
for 6 terms.
The seats must have been earmarked now.
Please, my lord.
Seats must have been allotted.
No, my lords, they say if it is a, if there is a repetition, then they'll have to change it to general. For 6 terms, my lords, it's gone to general, which is again section 42, section 240, article 243Z of the Constitution, and also against the direction of the Supreme Court. The same person is getting elected, general women.
What is it, Mr.?
I'll take notice, my lord. I have to secure instructions.
When shall we make it written?
The lordship may have it on Thursday, my lord.
He says that infectious.
28th, my lord.
28th, he says, my lord. Thursday will get back, my lord, with instruction.
Thursday, simply say Thursday, no notice.
Grateful.
Learned advocate, learned resident government shall take instructions on the next dates, 10th to 25th. In view that learned advocate for the appellant request an early date. Requested for an early date, yes.
Grateful minutes.
So number 18 is adjourned. So number 19, it's a commercial appeal, Mr. Rangaswamy.
Lordship, for the appellant in this case, the appellant is here with challenging the order passed by the commercial court in IA number 1 and 2. That is annexure A, Lordship. The appellant, the respondent has filed a suit for recovery of money on the basis of a cancelled, unstamped rental agreement, which was not duly acted upon.
Which order you are challenging?
IA number 1 and 2, annexure A.
Page?
Page 16, Lordship. If your Lordship permits, I'll read it. IA number 1, filed under order 11 rule 5, clause 1 of CPC is amended and Commercial Code Act, seeking direction to the defendant to produce the original lease agreement dated 6/1/2023. In his affidavit, the plaintiff Shri Vinesh V. N. Dinesh inter-alia stated that the defendant is the custodian of the said document. The defendant filed his detailed objection to IA number 1, inter-alia stating that the said agreement is mutually cancelled and agreement scheduled premises have been occupied by the new tenant. Hence, the said agreement was of no use to the defendant. Therefore, he destroyed the same. After filing the objection, the plaintiff moved IA number 2 under section 63 of Evidence Act, seeking
Notice.
permission of the court to
Notice
mark the
2nd
photo.
July.
Much obliged.
So number 20, the Shruti.
The appellant is the National Highways Authority of India. The National Highways Authority of India, my lord, was pleased to grant interim protection in MFAs, so pending conversion as commercial appeals. The MFAs are listed at serial number 86 and 87 today, but in the commercial appeals there is delay, my lord. So my lord had posted the matters to be considered today. Pure question of law involved, which is whether 15% interest on an arbitral award under section 72 of the 2013 Act is applicable to acquisitions under the National Highways Act.
We admit it. Appeal is admitted in view of the aspect submitted by learned advocate Ms. So and so for the appellant that the question involved is only about the grantability of interest by the arbitrator.
Well,
Delay is there.
there are delay applications, my lord. The reason is there was some confusion, my lord, on whether or not 15% interest is payable.
So notice will have to go. Notice returnable on 24th of July.
Interim protection, my lord.
No interim protection.
My lord, my only submission is that there is, my lord had granted me interim protection in the, I had originally filed them as miscellaneous first appeals. The execution proceedings are being precipitated, my lord. Special, attachment. I would undertake to deposit the entire arbitral award amount with the 15% interest before this honorable
Is
court.
that conversion?
Conversion, my lord.
So where is it, that MFA?
That is at 86 and 87, my lord, listed with my lords today.
So notice returnable on so and so, so and so. The present commercial appeal was permitted to be converted.
MF,
Serial number?
MF, serial number 86 and 87.
From MFA number
2726.
who matters common. These commercial appeals were permitted to be converted, heard so and so, so and so. Notice returnable on whichever date is given. It may be noted that these commercial appeals were permitted to be converted from MFA number 2726 of 2025 and MFA number 2727 of 2025, earlier filed, which was not competent in view that as per section 13 into 1 capital A, bracket over of the Commercial Codes Act 2015, the commercial appeal only was to be filed to be maintained. While permitting conversion, the court passed the following order. The court passed the order dated 15/4/25. At that time, it was the submission made by learned of the appellant that the order of attachment was already passed by the executing court and it was likely to be acted upon. In that view, this court granted the interim protection to the appellant by issuing direction that there should be no attachment till the next date. It is provided that in the facts and circumstances of the case, the said interim protection shall continue to operate till the next date.
But 21 is also connected.
Both common order will pass.
Seal number 22, miscellaneous first appeal.
For the petitioner, my lords. That's we're challenging the impugned order which is available at page number 23, my lords. The learned trial court, we're challenging the order for non-extension of the interim order, my lords. We are challenging the impugned order where the learned trial court has not extended the interim order, my lords. The impugned order is available at page number 23, my lords. This order was passed in a section 9 petition, my lords. Initially, the Honorable Trial Court had granted the interim order, and while it was listed for objections to be filed by the respondent, they filed a memo. Without hearing us, my lords, the interim order has not been extended, challenging that. May I place the facts, my lords, how the arbitration clause has come into play? The petitioners, my lords, are two senior citizens, my lords. They had entered into an agreement to sell in 2013, that is at Annexure B, my lords. With the first respondent, that is the GR Natras HUF, my lords. Then the second and third respondents, my lords, they had entered into an agreement to sell. Under the agreement to sell, there is an arbitration clause, my lords. The agreement was with respect to a unit called M4, my lords. They were to develop a residential villament project in that one unit. That unit schedule is at page number 38 of the appeal, my lords. During the pendency of this, my lords, on 10/6/2024, a registered gift deed is entered by the respondent, HUF, to its own karta, without mentioning any legal necessity, for this very same scheduled property, my lords. That gift deed, my lords, is produced at Annexure C, page number 47. Annexure C, page number 47, my lords, the gift deed is mentioned.
You notice. What relief you are seeking?
My lords,
what interim relief you are seeking?
My lords, to prevent the respondents from further alienating the scheduled property. Because, my lords, what has happened, the GR Natras HUF has transferred in the gift deed to the karta himself, against whom I have the arbitration clause also. Till such time, my lords, otherwise my arbitration petition itself will become infructuous when I go for arbitration. CMP is already filed, my lords. Notice of arbitration is issued. CMP is already filed, my lords.
So where is your interim prayer?
My lords, it's with an IA, my lords. What's IA number 1, my lords? It's at page number 203 of the petition, my lords. Page number, my lords, it starts at page number 203 of the appeal, my lords. And the application is at page number 205, my lords.
205.
205, my lords. It's the first application along with the appeal, my lords.
Section 9 application.
It's a section 9 application, my lords. Initially, my lords, the interim order was granted. Then, my lords, by merely relying on some judgment without
Where
an
is the
opportunity.
prayer?
Sorry, my lords.
Where is the prayer?
Of the appeal, my lords.
No, interim prayer which you are seeking now,
In page number 205, my lords.
which was prayed for in the 9 application, whatever.
My
205.
section 9 application also I have produced, my lords. Section 9 application is at page number 181, my lords.
You want only prayer.
Prayer is there, my lords. Section 181. Page number 181. In AA 24 of 1996, my lords. It is the same prayer what I have sought here.
Both properties, A and B, both. Both scheduled properties, A and B, both.
No, my lord, schedule A, my lords, M4, unit M4, my lords.
M4, what is B?
My lords, B is the full apartment, my lords. We are only with respect to that unit M4, my lords. But my lords, that is schedule A property in AA 24. Before this appeal, my lords, the application is.
Why the court has not granted the relief?
Sorry, my lords.
Why the court has not granted the relief?
My lords, initially it was granted, an ex parte interim order was granted
Where is
during.
in ex parte, where is that ex parte?
Yes, my lords. I'll just. My lords, it is at page. It was granted on. It's at page number 196. 8/7/2024, my lords. Much also got the detailed certified copies also. That time, due to urgency, I produced the.
No, we are not doubting, sir. We are just wanting to have the notice of that fact.
Yes.
Where is the page?
Page number 196, annexure H3, my lords.
196.
Yes, my lords. 8/7/2024 is the. Much I have the certified copy in my meeting.
Will apply here. Need not the arbitral proceeding. Quotation of still granting stay.
As the ex parte interim order was granted, it was extended till this date of the impugned order, my lords. On that day, without hearing us, my lords, merely based on a memo filed by the respondent, the learned trial judge has not extended the interim order, my lords.
The prayer in this appeal is to set aside the order dated 29/1/2025, passed by learned 83rd. 83rd.
43rd, my lords.
43rd. Additional City Civil and Sessions,
Yes.
Bengaluru, which was passed in the proceedings of application under section 9 of the Arbitration and Conciliation Act 1996 filed by the appellant herein. The order, by the said order, the commercial court below
My lords, it's a civil
refused
court.
to extend
Refused to
interim relief
extend the
and
interim.
vacated the relief. Full stop. The impugned order reads as under, and court, page 20, is green. Full stop. It could be submitted by learned advocate for the appellant that initially ex parte interim order was passed in favor of the appellants by granting injunction, restraining the respondents and their agents from alienating, encumbering, or dealing with the Schedule A property in any manner whatsoever till the disposal of the appeal. In any manner. However, the said order was the scheduled property is described as under, here it is 205, only A, Schedule A property. For not extending the paragraph, interim relief, interim injunction granted ex parte, the court below records that the arbitral proceedings have not been initiated within 3 months from the date of filing of application under section 9 of the Act. Therefore, the interim relief which was earlier granted became liable to be vacated. However, it is a fact recorded by the court below in the impugned order itself that notice is already issued for
It is already received, my lords. They have not objected.
Appointment
Section
of
11 has also been filed.
arbitrator.
Yes.
Full stop. In that view, prima facie, the reasons supplied by the commercial court below for not extending and vacating the interim relief does not hold good. Notice returnable on, say, let us go 2nd of July, little earlier.
Yes,
26th of June.
Yes.
By of interim relief, it is directed that the respondent shall not alienate, encumber, or deal with in any manner Scheduled A property described as above.
Grateful.
Number 23, writ petition PA, Mr. Upadhyay Arvind.
My Lord, I appear, my Lord, for response number 16 and 17. The last occasion, my Lord, I had undertaken to, my Lord, file power for response number 16 and 17. Today morning, my Lord, I have filed, my Lord, power for response number 16 and 17.
I will undertake to file wakalat.
1 second, yes.
My Lords, I will undertake to file wakalat for respondent 18, my Lords.
This is PIL.
PIL, my Lords.
I have, my Lord, undertaken to, my Lord, file power for response number 16 and 17, my Lord, on the last occasion. Today, my Lord, I have filed, my Lord, power for R16 and 17 in the registry. I will file my statement, my Lord, the matter.
You are for whom?
Let's respondent
I am
18.
for my
I
lord,
will
this
file
one.
wakalat.
Private response.
Private minutes.
We'll adjourn it after. What is it about?
Property and CL7 license, that is licensed premises that has been constructed, my lord, and in which a CL7 license has already been issued and it is in force.
License for?
My lord, CL7 license.
CR7 line, restaurant,
No, lodges and, my lord.
lodging.
Lodging.
The prayer is, my lord, the land utilized by these private respondents is belong to the government. It has been granted by the Bombay.
So license issued to you.
My lords, I am the owner, my ancestor since 1938, my lords.
So you are
Now
the
I have sold the portion of the property to respondent 16 and 17.
license is issued to whom?
My lords, now the private respondents, that is 10 to 16, my lords, is what is their contention.
You are the original owner.
I'm the original owner.
License is issued to respondent number 16.
We'll permit you to file wakalatnama, then we'll dispose of it.
My lord, I filed the IA number 1 along with my petition. It is not land belong to the government. In 1938, it is reserved by the Masanwati in the department. It is transferred to the Patan Panchayat respondent number 8. My lord.
I shall file, my lord, my statement on the very subject matter, my lord. Proceedings were initiated before, my lord, Deputy Commissioner under Section 306 of, my lord, Municipalities Act. Those were challenged, my lord, before the learned single judge, my lord, at Dharwad bench in a writ petition, my lord, by respondent number 16 and 17. Writ petition, my lord, was allowed and the writ appeal was preferred, my lord, by the town panchayat before the honorable division bench. In fact, my lord, the writ appeal has also been, my lord, dismissed by the honorable division bench on 8/4 of this month, my lord. I'll also place, my lord, the order passed by learned, my lord, single judge as well as honorable division bench, my lord, at Dharwad bench in the very same subject matter. My lord, some 2 weeks time may be granted, my lord. I shall place my statement as well as orders passed by this honorable court, my lord, on the report. Very, my lord, petition number 2 had initiated proceeding, my lord, before the DC. By suppressing the fact that he has initiated proceeding, my lord, before the deputy commissioner, this PIL was preferred. Now, my lord, the proceedings before, my lord, deputy commissioner have been set at naught, my lord, by learned single judge. An appeal, my lord, was preferred by the town panchayat.
The property was the graveyard, but it is reserved for the Patan Panchayat, respondent number 8.
No, my lord.
So without any title,
No, my lord, that is not.
they have occupied the government land and utilize the same, my lord. They are constructed building also.
No, my lord, this-
That has been, I produced the
No,
document pertaining to 1938. It has been transferred to the respondent Patan Panchayat. Along with my IM, I already have produced, my lord. The form number 6 also it says, my lord, the survey number 400 is reserved for the Masanwati. In that, creating the fake number of the Patan Panchayat, they have put their number kata also in their favor. In also kata also in the different manner. One name of the one person, one kata is in the different person. Both are same. Only they are changing the schedule of the property and mentioning the kata in the property extract, my lord. That also I produced along with my lord in petition. Annex is G, my lord. The old document is says, my lord, this properties belong to the government. It is reserved for the graveyard. Without any title, they have occupied the property of the Patan Panchayat, and now they are saying, this is the belongs to us.
So heard learned advocate, Mr. So and so, who appeared to video conferencing with learned advocate Mr.
Upadhyay, Arvind Upadhyay.
Who argued physically from a learned additional government advocate Mr. Nilofer Akbar, who appeared upon service of copy of the petition in advance. First of learned advocate Ms. Sadhana
Desai.
Desai was also heard, who appeared for
R18.
respondent 18, who is permitted to file for wakalatnama.
Yes.
And if filed within 1 week, the office shall accept the same. This petition paragraph styled as public interest petition seeks direction against the respondent authorities to consider the representation filed by petitioner 1 on 8/2/21. It is prayed that the respondent shall restore the property bearing number TPC 1015/1, which is claimed to be the property of Patan Panchayat at Chinchili, as respondent right here, and to take physical possession thereof after conducting survey. Full stop. The petitioner wants to take legal action against private respondent 10/18. The case pleaded, stated in nutshell, is that private respondents have illegally encroached land bearing survey number 400, now renumbered as TPC 1015/1 at measuring 2 acres and 10 meters, situated at Chinchili. It is stated that the Chinchili belongs to Chinchili falls within the Patan Panchayat, PAWT and Patan Panchayat area, and that the land in question falls within the limits of Gram Thana, THANA. It is the case that it was earlier handed over to Gram Panchayat of Chinchili and thereafter to respondent rate in the year 30th for 1938. It appears that the prior respondents thereafter, on the basis of TPC number 2004, sold off the property to different persons. It is stated that it is further stated that as per the government record, the land in question, it is alleged that as per the government record, the land in question is sold for graveyard by the earlier Kolhapur district magistrate, when the same was under the rule of Presidency of Bombay. The land was thereafter given to Panchayat, as per the case of the petitioners, and that the Panchayat has passed the resolution. It is the grievance of the petitioner that the private respondents have been creating fake documents and altering the boundaries to hold their possession of the property by creating fake TPC, and that they have been selling the parcels out of the said land to the different persons. It is stated that TPC they used was in the name of that they use the TPC in the name of one Srimati Ramabai Samba Rao. It is stated that the representation is taken, but no action is taken. Therefore, the present petition of the record be filed. Full stop. Having noticed the grievance of the petitioner from the averments made and the case put forth, it could not be gainsaid that the grievance of the petitioner has been pending with the competent authorities in the nature of representation already filed by the petitioner. Full stop. The authorities are yet to apply their mind to the grievance of the petitioner by looking into the representation. Wherever given otherwise, looking to the allegations and the factual pleadings, for the purpose of addressing the grievance of the petitioner, a factual inquiry is necessarily needed before any conclusion could be drawn. Full stop. It is not permissible nor possible for the court to undertake such factual inquiry in the writ jurisdiction. Full stop. The present public interest petition is therefore not liable to be entertained. Paragraph. The petition is how disposed of by granting direction, by directing the competent of the respondents to consider the representation of the petitioner dated 8/2/21 already pending with respond number. Where is that?
In
Annexure N, my lord.
Annexure N.
For whom you have
Annexure
before
N.
you filed before this number so and so so and so. The competent authority shall look into it and take appropriate decision in that regard in accordance with law and communicate the same to the petitioner within 12 weeks from today.
Obliged.
Please.
This court has not expressed any opinion on the merit. It is entirely for the competent authority to look into the merits and take its own decision. The present petition is dismissed subject to above limited observations.
Obliged.
24, PAL, Mr. N. Gautam Raghunath.
This matter pertains to the distribution of freebies, my lord. This matter is pending in before the apex court in Ashwini Kumar Upadhyay matter. Please, my lord.
It was stated that the subject matter is also pending before the Honorable Supreme Court. In that view, the same may be listed on next. The same may be listed. Same may be next listed on 25th of July.
Grateful.
This is number 25. Umapati, yes.
Here for respondent number 5 in this matter, my lords. Request for a short pass over, my lord. Senior counsel, my lord, is on his legs, my lord.
Pass or not possible.
Madam, tomorrow, madam. Tomorrow afternoon we have a matter at the session court, madam.
Very good.
Tomorrow, madam.
After vacation.
Madam.
What is the urgency?
Madam, this is a long pending matter which has been converted with the honorable single judge into a PL, madam.
What is the subject?
That school has been constructed without a sanction plan, without a stability certificate and without a fire certificate also.
11th of June.
Madam?
11th June.
Please, madam.
And also there is one IA is also pending.
As requested by learned advocate for the respondent on the ground that the counsel, senior counsel who is to conduct the matter is engaged elsewhere. Yeah. Take up. There is no such urgency. Next.
Much up.
This is number 26. It's a green bench matter.
My lord, this requires a detailed hearing if my lord could have
Notice
it.
returnable on
My lord, the
4th July.
notice already, my lord, ordered. Notice has been already ordered.
Then 4th
My
July.
lord,
Lord, I'm on interim order, my lord.
no, he's not been granted any
lord,
license, my lord. This requires a detailed hearing There's a slight confusion
Lordship-
that is trying to be, my lord, made out. My lord may have this immediately after vacation, my lord.
What is
The
the
lordship
subject?
has heard for some time this matter, wherein, my lord, the only short point is this, my lord. The land has been granted in the year 2016 for acquiring the lease for jelly crusher. After that, my lord, whether the property is, my lord, comes within the 1 kilometer or away from the 1 kilometer. And, my lord, two authority is saying, my lord, it is after 1 kilometer. Then, my lord, one authority is saying it is within the 1 kilometer. Then, my lord, I have made a representation before the competent authority saying that please resurvey. That is also not done. Then state has taken contention that, my lord, this is a deemed forest. According to the judgment of this honorable court, my lord, there is no deemed forest. The division bench, my lord, has already made.
Now you have appointed some committee to,
No, not committee, my lord.
I read somewhere.
Yes, your
I
lordship
had
has
undertaken to file an affidavit, proper affidavit from the concerned officer with regard to the confusion that had arisen, my lord, as to which deputy conservator of forest could have, my lord, given an opinion. My lord, for that I have filed an affidavit, my lord. My lord may have this
Identical
on the reopening. I'll argue it out.
My lord,
Things are complete.
for the identical, very next who has got allotment, my lord, they have got the permission to acquiring the, my lord, the lease articles. That is, my lord, jelly crushed stone, which is, my lord, required for the formation of the national highways, my lord, which is proposed by the central government.
My lord, my
For unless there is
specific
no stone, my
contention
lord, it is impossible for anyone. It is, my lord, granted in the year 2016. I am behind the all authorities, my lord, as per annexure K. Your lordship may kindly see that, my lord, running page number 209. It has, my lord, in the year 3rd April 2016, my lord, it was granted and considered. And, my lord, as per annexure A, annexure K, your lordship may kindly peruse it for a moment. Running page number 237, annexure P. This is in Gomala land according to the grant and grant certificate by the respondent authority, deputy commissioner, who is the chairman of the task force under the MMRD Act, my lord. Your lordship may kindly see the 237, my lord, page number, volume 2 of the repetition. 237.
interim prayer ಏನಿದೆ ನೋಡಿ.
So we are granting an interim. It will amount to grant the main relief.
Yes, my lord, and that too in a deemed forest, and my lord, specifically in paragraph 7 of my statement of
in the state of
objections.
Karnataka, my lord. I have filed the division bench judgment of this honorable court, my lord, before this honorable court on dated 13/2/2025. I have served, my lord, copy to my learned senior friend.
What
Wherein,
is
my
that?
lord, the division bench has taken the specific
Oh, yeah, my senior friend.
Call learned advocate Mr. So and so for the petitioner and learned
Lord, one
additional government advocates and Nilofer for the respondent upon service of notice issued by the court. Yes.
My lord, the judgment of my lord, that is division bench, this honorable court, former Chief Justice Oka has made a specific order. In the Karnataka, state of Karnataka, there is no deemed forest. And, my lord, now they are saying there is a deemed forest. That is, my lord, contrary to the judgment of this honorable court. That is not permissible to the state, my lord. Once, my lord, they have the opinion has been formed by this honorable court and judgment has delivered on the question of deemed forest itself. And specific judgment on the same point, there is no deemed forest in the state of Karnataka. Your lordship may kindly look into the, my lord, paragraph number 14 of the judgment, my lord. It is a reported judgment. Court officer. Paragraph number 14, my lord, your lordship may kindly look into the judgment, my lord. There are two identical judgments on the same circumstance by this honorable court, and which is reported judgment. And now, my lord, again state is, my lord, contrary to the judgment of this honorable court, my lord, made a submission. saying that this is a deemed forest. Running page number 14 of the judgment, my lord. I have put it in record, my lord.
My lord, paragraph 7
That
of
is,
my statement
Dhananjay
of
judgment.
The
objections.
prayer in this petition, next filed under Article 226 of the Constitution, is to set aside the map, which according to the petitioner is not in consonance with the directions public proceedings dated 20th 11 1915 1915 issued by the then Maharaja of Mysore, as also to set aside the village map produced on record. Full stop. It is free to direct the authorities to withdraw the observation of the range forest officer dated 28/1/2022, which treats the land at measuring 1 acre and 20 gunthas as per notification dated 30th/4/16, as well as the land survey number 23 and survey number 80 in the Thamma Nahalli, Kasba Hobli, Anekal Taluka, to be the forest land.
Gomala land.
Gomal land. The petitioner wants to carry out coring activities in the property in question. The case of the petitioner, briefly noted, is that the petitioner could obtain Form S from the inspecting officer in respect to the said lands, and it was opined that the land was about 1.2 kilometers away from the Madheswar protected forest. Full stop. Assistant Conservator of Forest, South Division, communicated by letter dated 5/8/15 that the said land, stated the petitioner, was 1.1 kilometer away from the reserved forest, and that the NOC could be granted. Paragraph. It is further, it is the case of the petitioner that after having proceeded to great extent and having invested the money, the forest authorities undertook joint survey in 2016-17, and it was notified on 20th 11/15. It was found that the survey sketch and boundaries were not properly drawn, and on that ground, the query license of the petitioner came to be rejected. Full stop. In facts of the case, the petitioner requires final consideration. Therefore, rule returnable on 29th July. Of learned advocate for the petitioner presses for interim relief. The interim relief prayed for is in the following terms. Page
24.
26, pending disposal. Full stop. There is no gainsaying that granting of above interim relief or even part of it would amount to granting the principal relief. Full stop. It is TRIT, principle that at the interim stage, the interim relief in the nature of main relief. Interim relief, which has the grant of which has the effect of granting the main relief, cannot be granted. Okay. Such course is not permissible. In that view, the interim relief is refused.
Obliged.
Please.
The stand of the respondent is that the land in question where the querying lease operations are sought to be carried out by the petitioner falls within the area of deemed forest.
Yes.
This aspect is required to be examined, and pending the examination, the petitioner cannot be permitted to continue the activity.
Very well. Please. So 27 is urgent. Still number 28.
License itself granted, my lord. Anyway.
28 Caste.
28 PAL.
After Caste survey.
Caste survey, but my lord, there is some urgency. My lord, I was permitted to make two submissions. Firstly, my lord, it's constitutionally impermissible with regard to the competence of the state government to conduct a caste survey, caste census. Because census in my lord, divide entry 69 of list 1 of 7 schedule is in the central subject. Now, my lord, it may be too late to say that some interim order may be passed after 10 years because the writ petition was filed in the year 2015, census was conducted in 2014, and the legal position under the Backward Class Commission Act in the state of Karnataka is that every 10 years under section 11, census must be conducted. Now the state government is hurrying to accept and implement this 10-year-old caste census. Basically, without even going to the question of whether caste census can be conducted with the state government or not, or the Honorable Supreme Court judgment that as a matter of policy, caste census has been.
You don't have time to hear the matter.
No, there's one issue, Lord. There is one short issue. Now it appears under the new caste census report submitted to the government.
It is already submitted.
It's submitted to the government.
Not published.
Some portions of it have come out in the media, not published. But issue is that cabinet intends to take it up on May 2nd. Now, Lord, suppose it is taken up. There is a Supreme Court order that governs the field. Kindly see this order, Lord, this Supreme Court order copy. Yes. It appears, Lord, let me just clarify the position. Lord, in 2023, the state government made a new quota order. The state government made a new quota order. That quota order was questioned in the Supreme Court.
New quota order.
New quota order.
The basis of the caste survey.
On the basis of not this caste survey, but on the basis on sumoto it had made a quota order. There, my lord, the some percentages for some OBCs was increased. That was the effect of the order. When this came up before the Supreme Court, the state government gave an undertaking. We further record the following statements made by the learned Solicitor General. Impugned order stated 27/3/23 shall not be implemented till the next date of hearing. He further submits that earlier regime relating to reservation, notification dated 30/3/2002, will continue to hold the field till the next date of hearing. Therefore, my lord, before this 27/3/2023 order, the 2002 order quota fixation was in force. Now matters are seized before the Supreme Court. And what will hold the field according to Supreme Court's direction is the 2002 quota fixation. Now our anxiety is, or what the state government will do upon accepting this report, May 2nd. If it accepts or looks into the report, that's a different question. But it cannot cut into the quota fixation which will hold the field upon the Supreme Court's order. That is the grievance now, my lord. What they will do,
They do at their peril.
Please, my lord.
The state government do something which tinkers with the Supreme Court order, that is their peril.
Correct, Lord. But now, if acceptance of this new report means, if they accept this new report, then the quotas will change automatically. Because they are going by a census report. Now, Lord, the legality of this census report.
The acceptance of report will not override, will be able to override this direction.
Lord, what they will do is they will, upon acceptance of the report on the basis of the new population census, they will proceed to fix the quota. That has to be protected, Lord.
Any other petition also like of this nature? I read in the morning some other matter about publication of caste survey. This is the petition of which year?
Well, the second one, 28.1, is the earliest point of time. It was filed in the year 2002.
No, latest, which is latest in point of time. 29.
29 is.
Who appears in 29?
I'm for the petitioner in that. 29.
So that is the real petition, last petition against the latest caste survey.
Correct, Lord. Now, Lord, till that legal.
What is your petition?
This petition also is challenging the caste survey.
Very caste survey.
Very caste
West.
survey. That's the oldest in point of time.
Because in 2015, 16 or 17, they completed this survey, alleged survey.
Today, then day after tomorrow, we'll apply our mind.
Day after tomorrow, Lord.
We have to, at least I have not seen the dimensions of the matter.
Please.
To argue a day after tomorrow.
Lord,
we'll apply our mind.
please, at 2:30, Lord, if possible.
Day after tomorrow, with date?
Lord,
Or on
24th.
Friday.
24th. Day after tomorrow is Thursday.
Yes, my lord.
24th,
24th, please.
you give me.
And 29 should be tagged, Lord. 29 could be tagged.
Both you give me for reading. Both.
29th, huh?
Madam, you also get ready.
Yes, my lord.
They
Then-
are reading some intersection with the Supreme Court.
Yes, please. Oblige.
The Union of India has filed an affidavit that the writ petition may be allowed in that in 2015 writ petition.
Who?
The Union of India supported the petitioner's cause and will create this honorable court to allow the writ petition.
No, today you are apprehending some conflicting
Yes.
action by the state government,
Yes.
not in consonance with or nullifying the Supreme Court order.
Yes.
Directly or indirectly.
That's-
We understand, but let us
That's the
apply our mind.
Please.
What can be done? Yes, you are also there, Mr.
I appear for the commission, backward classes commission.
Commission. You
a
have done your job.
A senior advocate of this court, he is newly appointed as chairman. He has just now requested me to seek some short accommodation any day
Given.
after the vacation.
Short accommodation is given. They have some case to plead.
Yes, he has just taken
So-
over. He has just taken over as chairman of
But
the
the new
commission.
chairman will have no role once the
So
report
it may
reaches
be
the
called
government.
Immediately after vacation, by which date?
They are seeking some indulgence. We don't know whether we'll grant or not, but let us see. On
So
day
these are
after-
all old matters. In fact, they were extensively heard on the question of interim prayer.
Let us see. Day
And
after.
because he needs some breathing time, he has just taken over as the chairman.
That
He
is-
wants it to be called.
He has no role to play in this case.
No role to.
No, commission has already done its job and the government.
That is what we told.
On record, the government had submitted, pursuant to your lordship's query to the government advocate, that the report is accepted. Then.
We'll see on that.
It is
day what
against,
we do.
it is against, it is
Day after
against the
tomorrow.
commission report, the
Mr. Government, you have to get ready. You are the ball is in your court as far as the
Yes,
proceedings of 24th is concerned.
absolutely. Please.
This is number 30, so PAL, Mr. Ramesh Nayak L, party in person.
Matter is about the contamination of drinking water. State has filed a statement of objections, my lords.
State has filed something?
My lord, I have
State has
filed a
filed an
detailed,
objection. I went through it. It provides details about how the rural drinking water system works, my lords. But the action taken with respect to northern Karnataka district, upton district, my lord. But with respect to Tumkur district, my lords, I have some serious objections, which I may be permitted to file an rejoinder to that, my lord. Because Tumkur district, my lords, with respect to Tumkur district, lot of information has been considered in this report, action taken report. And also the prayer 2 is, my lord, just one direction I sought. Prayer 1 is met in part. Prayer 2, my lords, I sought one short direction to all the local authorities to clean the water storage facility in every villages, from where ultimately drinking water is being supplied to all the households. That short direction, my lord, that is not being met, my lord. I will place all those details in the next date of hearing. Prayer 1 is met in part. Prayer 2 is a simple direction, my lords, because whatever could be the source of water supply, but ultimately because my lord, whatever could be the source of water supply, ultimately in every village.
We may dispose of by giving some observation. that they will maintain the.
That is what, my lord. One direction, I request state to pass one direction to all the local bodies. The water storage facilities, the tanks and all, my lord, it may be cleaned at least. Because water storage facilities, my lords.
Heard learned petitioner part in person, Mr. Ramesh Nayak.
Yes, Ramesh Nayak.
For the petitioner, and learned additional government advocate Srimati Neelo Farakpur for the respondent from at length. Learned part in person, learned petitioner part in person, as learned the respondent stated that they argued the petition. Finally, they further stated that the pleadings are over and no further are required to be added or supplemented. Resort for judgment. Resort for orders.
Obliged.
With respect, prior to, my lords, one simple direction, because
We'll
ultimately water is being supplied through the storage facility in every village.
We'll
That
do
is to be cleaned at least once in a 10 days, 8 days,
We'll
1
do.
month, one specific direction.
We'll appropriately deal with.
Yes.
So number 31, the green bench matter, Mr. Ravindra Gajanan Pulle.
My lords, requesting for short accommodation, my lords.
At the request of learned of the petitioner, from as prayed for, stand over to 10th of July.
Grateful, my lords.
So number 32, Mr. Ravi HK.
My lord, in this, I pray for some time, my lord, because we have to provide alternate land since
Stand over to 18th July.
obliged.
So number 33, Mr. Rajendra S.
APF for the.
It's a PA.
Last date, your lordship had directed the state to file their reply. Filed.
Lord, I pray for some time.
My lord,
That shall
one
be filed before the
submission,
next date put upon.
one submission, my lord. My lord, respondent number 7 is running a educational institution, and this petitioner has filed 6 public interest litigations which have been suppressed in this. My lord, now he files a rejoinder. By mistake, all that petitions were not mentioned in the present petition. My lord, there is the respondent number 7 has constructed the building as per the building bylaw and the plan. Now, school has to open in the month of June. Door number is not given, though there is no interim order in this. Panchayat has not issued a door number, and everything is held up. 1,800 students' life depends on this. So, there is no impediment for the Panchayat to issue door number.
And the interim leave is there.
No, that's why I'm making a submission, that a observation that there is no impediment for the Panchayat to issue a door number. That would suffice. Otherwise, by merely.
We'll keep it immediately on reopening.
By the pendency of this petition, my lord, they are not issuing.
Stand over to 4th June, before which date the reply shall be filed invariably by the respondent.
A date may kindly be.
4th June.
Please.
So number 34 is Neha Nagraj, the PA.
Appear for the petitioner in this matter, my lords. This petition is concerning advanced medical directives. Now, the state government has appointed the competent authority. On the previous occasion, I had filed a memo seeking a specific direction on the limited aspect that this honorable court may direct the competent authority thus appointed to collect, store, and maintain the advanced medical directives. Now, my lords, the object of this petition was to get a competent authority appointed, which admittedly the state government has duly appointed. But however, the essence of the common cause judgment passed in 2023 by the Honorable Supreme Court is that there must be an authority who is authorized or vested with the powers to collect and maintain these records, stored in a manner where tomorrow they can be given effect.
My lord, we have the petitioner's, my lord, doubt is cleared in paragraphs 198.3.5 and 198.3.6, my lord, of the modified judgment of the Honorable Supreme Court. We have provided that, my lord. I'll file it with a memo if my lord were to grant me 2 days accommodation.
My lords, in fact, I insist that as if I may take my lords through page 261, I have produced this judgment.
You have not filed any reply.
My lord?
Reply is not filed, but
My lord, I have filed a memo, my lord, with a GO on 19/2/2025.
19 to, yes.
Yes, where we have complied with the order of the Honorable Supreme Court, my lord, but there was a doubt raised with regard to directing the competent authority, my lord, to preserve, to collect, store and maintain these directives. My lord, which is clearly spelled out in these paragraphs.
Which paragraph?
My lord, may have this day after tomorrow. I'll file the memo along with.
My lords, in fact, I have produced the judgment, and just to add to what learned counsel has stated, it's at page 261 of my petition.
Which learned officer?
Learned counsel. What they are stating essentially is covered in page 261 of my petition in the modified judgment passed by the Honorable Supreme Court, where the Supreme Court holds that the copy shall be handed over to the competent officer of the local government or the municipal corporation or municipality or panchayat, as the case may be. The aforesaid authority shall nominate a competent official in that regard, who shall be the custodian of the said document. Now, I have no difficulty insofar as the competent authority already being appointed by the state government. The state government has complied and appointed a competent authority. The only remaining issue is that the essence of the judgment is that they ought to be vested with the power to collect and maintain these records. That is the limited plea that I have before this honorable court today. There's a prayer in my petition as well. I've filed a memo to that effect. May be allowed. There is no impediment, because there are hundreds of senior citizens who have already executed their AMDs. But today there is, even though there is a competent authority nominated, there's no place for them to go and deposit. So just a very limited direction that they can collect, the competent authority already which has been appointed, if they can collect, that can effectively dispose this petition, my lords.
You can give your inputs in writing. In the meantime, she will.
I have filed a memo, my lords.
She will be filing some further memo on day after tomorrow.
Please, my lords. Day after tomorrow, then.
Day after.
Not an issue.
Seal number 35, Rajay Rao.
That's, we have to file the objections. We have to file the objections, my lords. It's a matter, my lords, they have an interim order. They are protected.
You are protected.
Please, my lords, may have it in the second week of June, my lords. We'll
Since
file
learned advocate Mahesh Chaudhary for the board.
Yes, my lord.
Pollution Control Board wants time to file objections. From stand over to 30th June. Interim order shall continue over till further orders.
Please, my lords.
We had a judge in Gujarat.
That's
We had a judge in Gujarat. Whenever she was a lady judge, very fast. She later became Chief Justice of Orissa High Court and retired there. She never used to grant any relief till late. She always believed that if relief to be granted by this court, till further orders. It will save. It will show the determination of the judge, and it will save the court from extending it time to time.
That is one, my lord. Then second thing is what happens is it starts, my lord, hindering your lordship's other work.
Correct.
Not only for extension, it has to come up before your lordship. Therefore, great.
36, same.
36 also. Sorry.
Thank you.
36 my lord, also my lord, same.
Both are stacked petitions. 35, 36, same orders.
Same orders. 36.
Both,
Yes.
both, same order.
Seal number 37, Mr. Murugesh V. Charity. 37.
For respond number 2. Batch matter, my lord. My senior held up in the batch matter. Kindly have it another day. My senior arguing in batch matter, my lord. Kindly have it in another day.
After vacation. Any urgent?
Immediately after vacation, not the
Immediately
respond
means 13th of June. 13th of June.
Please.
Next.
Seal number 38.
This matter, my lords, the state appeal, my lords. Naveen Chandrasekhar is looking into the matter. He has met with family medical emergency, my lords. May I have it tomorrow, my lords? Please.
11th of June.
Oblige, my lords.
Thirty-nine is urgent. Seal number 40. So state appeal.
Still mentioned.
39, my lord. I'm sorry, my lord. 39, my lord. It appears it has been adjourned.
What is got it adjourned?
Well, my lord.
Number 40.
I appear for respondent 1. My lordships, the issue is.
State appeal, my lord.
Let them argue. Yes.
My lord.
The issue is erroneous fixation.
Let the appellant start.
Lord, the
You are the appellant?
I am for the respondent 1, my lord. I am the aggrieved party, in fact.
and
Therefore,
complainants in the contempt petition, my lord.
Let the appellant start in appeal. Yes.
My lord, the matter relates to fixation of pension, my lord, of the writ petitioner. A request was made, my lord, for fixation of the pension on the basis of the post held by him in the respondent number 2 company, my lord. He was appointed on 13/10/1978 with the respondent number 2 company, my lord. In the year 1998, my lord, there was the merger of the company. After which, my lord, he has continued with the service in the respondent number 2 company, and he was granted the promotion as a general manager, my lord. Thereafter, he attained superannuation in August 2013. Then a representation was given, my lord. The government has extended, by a policy decision, my lord, extended the pension for the employees of the respondent number 2 company, my lord. He originally joined as a chemist. By way of an internal promotion in the company, my lord, he retired as a general manager. Now, my lord, in 2019, my lord, pay came to be fixed based on the KCS rules, my lord. Now, my lord, a representation was given that his pay should be fixed based on the post held by him in the company, my lord.
So he was the appointee employee of the Karnataka soaps and detergents.
Please, my lord, he continued to be in the service of the respondent number 2, Karnataka Soaps and Detergents Limited.
Then what happened?
My lord, he was initially appointed as a chemist, my lord. He was initially appointed as a senior chemist. My lord, at the time of merger, my lord, an option was given for them, my lord, either to avail.
Merger with?
Merger was in 1980, my lord.
Merger with which company? Merger with which company?
KSTL.
My lord, earlier it was Mysore Soap Factory, my lord. It was merged with the respondent number 2, my lord.
My lord, may I just submit? My lord, it was
Lord, page number 135 is the order.
Still. ನೀವು ಕೊಟ್ಟಿರೋ ಕಾಪಿ ನಂಗೆ.
My lord, it is at page number 135, Annex D.
135, my lord.
If you kindly permit me.
Correct, point.
It is not merger. The subject itself says it's a transfer of.
My lord, transfer upon merger, my lord, transfer of employees upon merger of the company.
No, it was not a merger, my lord. It was a transfer of the government soaps and sandalwood factory employees, which was under the directorate of the government soaps and sandalwood directorate. This unit was merged with the KSDL in 1980. In fact, I joined in 1978 as a chemist. As my learned friend said, it is not senior chemist. My lord, kindly peruse Annex A, my lord, if you can kindly permit me, page number 53, 54, and 56. In 56, I joined as a chemist.
Yes, there is a translation is available of 18/7/18 government order.
Yes.
My lord, that is, the government order is available, my lord, at page number 220 is the translated copy of the government order, my lord. Annexure H, my lord. Lord, pursuant to an order passed by this honorable court in writ petition 48089, my lord, the benefits of the pension were extended to these employees, my lord. Page 225 may kindly be seen, my lord.
We hear it.
Very well, my lord.
Appeal is admitted.
There's a connected contempt, my lord. The appeal has been tagged on along with that.
Appeal is admitted to be posted for hearing on 9th of July, 11th of July.
It is not page 225. It is the part 1.
On
My
11th.
learned friend is quoting part 2 of the order.
On 11th July will hear.
Yeah. It is
11 portion, sir. It starts from page 20, I said.
July 11th.
11 portion is 225.
18/7/2018.
Correct, that's what I referred.
We are here on 11th July.
Yes.
July.
My lord,
Date ಕೊಟ್ಟಿದ್ದಾರೆ.
December 41, Sanjeev BL.
my lord, I pray your honorable lordships to give an early date. I have been before this court. I retired in 2013, my lord. The decision of the single judge is very just. They have failed to
Early, you
implement.
want early
The
day-
early
early
date probably is day after tomorrow, even
No, no, it
tomorrow. My lord, it's 13th year. The erroneous fixation I have been fighting since 13 years. I retired on
13th June.
31, my lord.
13th June.
13th June, 13.
Early will.
13.
Before vacation would be much.
Not possible.
Seal number 41, Mr. Sanjeev BL.
Matter, my lord. This single judge, my lord, has passed an order.
Delay is there.
Yes.
Nobody appears.
My lord, I appear
Delay.
for the respondent.
Only respondent.
60 days.
Actually, order passed by the my lord, single judge is covered by
They
the.
can be condoned.
What?
You can condone
Delay is
it.
there, my lord.
Delay.
My lord, so far as delay is concerned, my lord, I have no objection. But on merits of the case, my
One of
lord, I
24, heard learned advocate Mr. Sanjeev BL for the applicant and learned advocate Mr. Sri appellants applicants and learned advocate Mr. Srinivas K for the respondent. This application is filed paragraph to condone the delay of 61 days, which has taken place in filing the writ appeal, filing the appeal. Course of the appellant is the Bangalore Electricity Supply Company Limited and its authorities. Full stop. The accompanying affidavit explains the passage of time leading to delay to the extent of 61 days. Full stop. The applicant is impersonal body, therefore decision-making process invariably consumes some time. Full stop. Viewed from this standpoint and further considering the principle that the delay and some explanations given, comma, should be viewed and treated leniently, comma, it could be said that sufficient cause is made out to condone the delay of 61 days. The delay is condoned, application is allowed. Appeal afterwards.
Lord, one submission. This is a case covered by the settlement which was entered into, my lord, in the year 2004. But since, my lord, since then, my lord, the respondent, my lord, is out of employment, and the similarly placed employees have already been reinstated. I am the only one, my lord, who have been left out. Kindly, my lord,
It doesn't
any-
come under the scheme, my lord. We have passed an endorsement subsequent to filing of the writ appeal, my lord, and now he has to challenge that.
endorsement has already been set aside. Direction was issued. Similar endorsement once again, my lord, has been issued, giving the very same reasons. Any small short accommodation, my lord, your lordship.
19th June.
So 42 is adjourned. Number 43, Mr. Shrikant MP.
For appellant. Notes, the order was passed in November. Copy was available in March. Immediately thereafter, notes, I preferred a review, which was dismissed and notes writ appeal is filed. Notes, Lordship may condone the delay and notes post the matter for admission. Notes, my appointment is set aside by virtue of the order of the learned.
Objections to him, my lord. I served a copy of my objections. I'll file it today. The objections I'll file.
Objection to?
To the condemnation of delay application.
File it. Learned respondent, Mr. So-and-so wants to file the objections to the prayer for condonation of delays. In that view, time is granted, stand over to 26th June.
Lord's little early, my lord. In fact, my appointment is set aside, out of employment. Lords.
See on that.
This is seal number 44. Mr. Dinesh M, party in person. 44.
This can wait after vacation.
To the respondent number 1.
13th of June.
14/6.
Or sell little later. 20th June.
20th June. Seal number 45. Abhinav Ramanand. 45.
None is
Short accommodation.
time, request for time was made. Learned on behalf of the appellant, stand or when do you want? July?
July.
Or July? Yes.
Seal number 46. Srimati Tanuja MV.
Happy for the appellants, my lord. Notice was served on the respondent, my lord. He has to file the.
Stand or to July 16. 16 July.
Seal number 47. Gautam Dev C. Ullal.
Respondent, appellate counsel. My lord. The short point is about the validity of the transfer order being set aside by the learned single judge, my lords. My lord, transfers could be effected, my lords, during the, we call it as the transfer season, my lords, general transfer season. And during that season, my lord, that's in 2024, the season was, my lords, 25th June 2024 to 31st July. My lord, he was initially transferred on 12th July 2024, my lords. And then they found that there are inquiries pending against him, and that transfer order is recalled immediately, my lord, on 31st July. Within the general transfer period itself, my lords. This was challenged, my lords. The learned single judge says he's already transferred once, therefore he cannot be transferred again. It cannot be cancelled. This is the
against me, my lord, no enquiry was pending. In fact, my lord, by considering the fact that the appellant before the Sambu court has been working in the same place for more than 8 years. My lord, I had been, my lord, transferred to, my lord, to the place where the appellant was working. Because, my lord, I have been left with 1 year of service. And, my lord, I had sought for due to health problem, my lord, I requested for transfer to my native taluk. So hence, my lord, by considering, my lord, the policy of the respondent corporation, I had been transferred, my lord. Though, my lord, I had been transferred.
After vacation.
No, my lord, the serious, please, serious allegations were therefore transfer order is recalled by them, my lords. Therefore, my lords, now he is continuing there because of this impugned order, my lords.
I have been relieved, I have taken charge, my lord, I have been working.
Because of the impugned order.
16th of June.
Please, my lords, please.
Number 48 for restoration of writ appeal.
So delay application of 7 days. Anybody appears?
Please.
Then notice returnable on 11th June.
But I may be permitted to rectify the office objections in the meantime.
Office objections shall be rectified before the next date.
Great.
This is for restoration.
Lords, there was a preemptory order which was passed.
Or recall of the
Because
order.
of that, I was not permitted to carry out the
Then
office.
common order in IA number 1 of 2 of 25 and IA number 3 of 25. Delay has occurred in filing the restoration application. Sufficient cause made out to delay the condon, as the party should be should be given opportunity to contest the case on merits rather than being thrown out on technical grounds. Therefore, delay is condoned, application is allowed. Then order in IA number 3 of 25. It appears that the writ appeal was dismissed on the ground of non-removal of office of business within stipulated time as directed by the court. So this application filed seeking restoration, stating that for bona fide reasons, the office of business could not be rectified at that time. Learned advocate for the applicant submitted that the appellant applicant submitted that the appellant is ready to remove all the offices objection within the time which the court may grant now, full stop, for the reason that the parties should be permitted to contest this case on merits, comma, and that the appellant is ready to remove the office objection, comma. It is provided that the present application is allowed by restoring the writ appeal number 189 of 25 to its original file on condition that whatever office objections are left out from being removed, comma, shall be removed within 10 days.
10 days
from today.
Great.
Number 49, Mr. Somshekar RP, contempt.
Respondent.
Nobody is there. Then it will go to July 14.
Number 50, Mr. KV Narasimhan.
In this matter, they have filed a compliance affidavit, my lord. They have filed a compliance affidavit, but they have not filed a compliance affidavit. They have not complied with the order, my lord. The order for compliance is, my lord, to conduct a podi and durust work. My lord, they have stated in their affidavit.
Lords, although the affidavit is
After
filed.
receiving the report from the special land acquisition officer, then they will proceed with the podi and durust. They have this is what they have taken the ground, my lord. My lord, this cannot be a compliance of the order. My lord, we have to file a rejoinder to this affidavit.
The only direction of learned single judge in his order dated 18th April 24 was to direct the respondent Tehsildar. क्या लिखा आपने? What did you read? In order dated, not wide. In order dated 18th April 24 was to direct the respondent Tehsildar to consider the application of the petitioner and do the needful expeditiously, full stop. The application from representation petitioner was with respect to conducting the survey sketch and 40, full stop, in response to the allegation that the application of petitioner has not received consideration, the compliance affidavit is filed by the respondent in this contempt proceedings to annex therewith an endorsement dated 12/2/25 passed by the Tehsildar, Tena, Rasipura Taluka.
My lord, if
In
it
which
is,
it is stated
I'm sorry for interfering, my lord. If it is disposing, my lord, maybe it may be taken up tomorrow, my lord. I'll seek instructions on it because, my lord, they have not, this is what my instruction is, my lord. They have not complied with the order.
which it is stated about the, in which it is stated in respect of the application of petitioner that the special land officer Nemavati Reservoir Project Hassan is to verify about the genuineness of the claim of the petitioner and to submit report, and immediately after receiving the report, some action will be taken. It could be said that the application of petitioner received consideration and the respondents have activated themselves towards the prayer of the application in the of the petitioner. It marks compliance of the direction. Contempt petition does not survive. It is required to be
I may be reserved liberty, my lord.
stop as not surviving. Full stop.
It may be reserved.
Petition is dismissed accordingly.
I may be reserved liberty, my lord, at least to challenge.
All liberties are there. We are here. You are here.
My lord, they have, my lord, the direction of this learned single judge, my lord, this honorable court, the single judge, my lord, to consider my representation and to conduct Podi and Durast, my lord.
Consider.
My lord, they have not considered, they have not made a Podi and Durast work.
Consider doesn't mean favorable. Chalo, next.
At least, my lord, liberty may be reserved, at least.
For what?
To challenge the endorsement, my lord.
It is open for the petitioner to challenge the endorsement on its own merits by instituting independent proceedings in respect of which, however, this court does not express any opinion or merits.
Obliged.
Number 51, Mr. Keshav Murthy B. Number 51.
I appear for the complaint, my lord.
Yes.
For the respondent, my lords.
This complaint shall file this petition for the disobedience of the order passed by the learned single judge on 26 July 2023. My lord, they have issued an endorsement saying that they filed an objections along with an endorsement on 12
Affidavit is filed and endorsement is issued, my lords. And there cannot be regularization for the lords since they were an outsourced. To that effect, an affidavit has been endorsement has been issued. 12/9.
Yes, come physically.
Yes, my lord, liberty to challenge that endorsement may kindly be disposed of this matter.
Dispose of all. So same order. It could not be disputed by learned advocate for the petitioner that since the endorsement is passed by the competent authority and produced along with the compliance affidavit, the contempt would not survive as the directions of learned singles could be said to have been complied with. However, learned advocate for the petitioner requested the court to grant liberty to the petitioner to challenge the said endorsement. Endorsement, which is the endorsement 12/9/24.
R2, my lords. R2, 12/9/2024 endorsement is issued.
Pehle, endorsement ki date. Said endorsement in the beginning date. In the beginning date. Not to be written everything which I speak. You must attend to the court and then write. Correct. Everything I go on speaking need not write, need not be written. So in the beginning, I am telling that you mention the date of the endorsement. Next.
Cell number 52, Mr. Shailesh. Yes, so.
Appearing for the complaint, my lord.
I appear for the respondent.
They is still not taken as gunman.
I'm filing my reply affidavit, my lords.
What is the
affidavit.
reply? What is the reply?
My lords, what has happened is against the learned single judge's order,
Yes.
had preferred an writ appeal, my lords. It can be found in writ appeal 1352 of 23.
Continue
In fact,
Ravindra as gangman.
Writ petition also, writ appeal also
writ appeal
dismissed,
also
my lord.
came to be dismissed, my lords. Subsequent to that, we had filed a review petition, my lord. Since there was some error apparent on the face, we have filed review petition. The status may be permitted to file. Due to which the learned single judge's order.
You are continued or not?
No, my lord, they are not taken as a gunman, my lord. There is, my writ petition are allowed and directed to Konkan Railway take as a
Since
gunman.
the
my
review
lord.
petition is pending, my
No
lord.
review petition. You give the job to this Ravindra.
Against the writ
Or you
petition, they
remain
are,
present. Who is the senior manager of the railway? Regional manager railway. Who is that? Let him remain present tomorrow. He is here or elsewhere?
It's from
Regional railway manager Bala Sahib Nikam. Where it is station?
Karwar, my lord.
Karwar. Then let him come on 26th. Either you provide job or the manager should be here. What do you prefer?
My lord, this is my instruction, my lord. Since
No
the review
instruction.
petition was
Now it
pending.
is our direction. What do you prefer? Either you bring your client here, number two here physically to face the explanation of contempt, or comply with the order.
I'll seek
Give the job
instruction.
to this petitioner.
I'll seek instruction, my lord.
No
regarding
instruction.
this.
What do you prefer now? Only two options are left. No excuses for review and appeal, and it is long back. It is what date?
my lord,
23. Yes, Mr. Counsel.
Review
tell us.
petition, it was
What-
filed.
No. Are you
April-
going to give the job to the petitioner, subject to all orders which will be passed in review, or you are bringing your regional manager here?
A short date may be given.
No
my lords.
date. Absolutely nothing. No third option.
This is my instruction, my lord. This is
No instructions. It is our direction now.
We have filed review petition in
No,
3 months.
we will not recognize the review petition unless any order is passed. Yes, what do you want? Full stop. There is a gross contempt of court inasmuch as the directions of the court in order dated 20th September 2023. Directions of the court passed as back as on 20th September 2023 has not been complied with. The direction was to continue the petitioner hearing, one Ravindra,
as a gunman, my lord.
as a gangman in the establishment of Konkan Railway. Full stop. There is a blatant disregard of the direction as the applicant is not continuing service on the pretext that the review application is filed. Full stop. As noted earlier, the directions are passed in the order, which is as old as which is delivered. The directions contained in the order, which was passed in September 23. Full stop. In the circumstances, full stop. The court has no option but to direct respond number 2. Sri Bala Sahib Nikam, Regional Railway Manager and Appellate Authority. Who will comply with? Who will comply with the order?
The head office is in Mumbai, my lords.
Who will continue?
ಯಾರ appoint ಮಾಡೋದು continue.
It is the second
one?
petition, second respondent, my lords. Second and third respondent.
Let Santosh Kumar Jha, Chairman cum Managing Director, remain present.
Please.
Yes. Number 3. Chairman cum Sri Santosh Kumar Jha, Chairman cum Managing Director, Konkan Railway Corporation Limited, shall remain personally present. On which date?
It's any date, my lord, maybe.
Tell the date.
Have to seek instructions.
To
my
remain
lord,
personally present before the court to explain the conduct which is evidently contumacious, CONTU MSCIUS. Full stop. Learned advocate Mr. So and so and so at this date states that this 1 3 shall remain personally present on which date?
Maybe after vacation. My lord.
No.
Since the respondents from Mumbai, my lords, they have to.
Wherever outer. It takes 2 hours in flight. Yes. Tell the date, other we'll provide the date.
After a week, my lords. After a week.
After?
A week after.
On 29th of April. Learned advocate Mr. So-and-so at this stage stated that the respondent shall remain present on 29th of April at 2:30 before the court. Full stop. It is however provided that if the order is complied with in the meantime and the petitioner is taken back in service and continue in service, comma, the personal presence of the respondent shall stand automatically exempted.
Obliged.
In that event, the respondent shall produce the copy of the evidence that the petitioner is taken back in service.
Obliged.
This is bill number 53. Mr. Vasant Kumar HT.
Complaint in this case, my lord. Till today, they have not complied, my lord.
Lords, the authority has preferred an appeal against the order brought under contempt.
What is the status of appeal?
Lords, it was filed yesterday, my lords.
Oh, my lord, there is.
If my lords were to
Stated that the writ appeal is filed in respect of the order brought under the contempt jurisdiction. In that view, by providing that the writ appeal shall be court listed for admission purpose after removing all of his objections on or before 13th June, the present contempt proceedings are directed to be listed on 19th June.
oblige. Same order may be passed in the next matter, my lords. 54.
Same order in the next.
After a lapse of 8 months, my lord, they have prepared the writ appeal, my lord. Till today, they have not.
What is the direction? Let us.
Lords, the direction, my lords,
To execute the sale deed in respect of site.
calculate the sale cital value in respect of the site as prevailing on 31. Please. Oblige.
Bill number 55. Mr.
Please, my
Trivikram
lords,
S.
I prepare for the complainant, my lords. There is no compliance report till date, my lords. I had made a innocuous prayer before the learned judge.
Learned advocate Mr. B. Sanjay wants time stand over to 10th of June. Before
Yes.
which date the compliance affidavit shall be filed.
Grateful.
Bill number 56. Mr. HR Shourie.
An inquiry is supposed to be conducted against the committee of temple millets within a period of 8 weeks. That has not been complied.
That is to be done by the Rajya Dharmika Parishad, my lords. Separate counsel is a panel advocate for the Rajya Dharmika Parishad, my lords.
Appearing or not appearing?
In the writ petition, my lords, one Mr. Harish had appointed.
I've served them a copy as well, millets, on the last date.
Inform them.
Millets, only difficulty is that, millets, the inquiry should not be dragged to an extent that the committee would lose the term itself. Millets, the term is ending on 23rd of May.
Committee's term.
Pardon, millets?
Term of the committee.
Committee, millets.
Term of the committee is ending.
Please, millets.
Which is conducting the inquiry.
Please, millets.
Where is that direction?
Millets, at page 19, millets. Three lines from the top, millets.
Then inform the council.
Please, millets, action.
Day after tomorrow.
Please,
Obliged.
Day after tomorrow at 2:30.
Please.
oblige.
Bill number 57. Mr. Basuraj R. Bannur.
Petition matter pertains to payment of arrears of salary. My lord, writ appeal has been filed and dismissed, and this now court granted 6 weeks time.
Filing a memo to the, my lord. The proceedings has been initiated, my lord, to revise the pay scale of the complainant, my lords.
No, Mr. What is the direction?
Direction is to pay the salary, my lord, appointment of salary grant was made on 22/11/2004, which was ordered to be given with effect to from 9/6/1999. He is retired from the my lord, service. Only arrears of salary has to be paid. not paid not so far.
What is your stand?
My lords, that with regard to the revisation of the fixation of the pay, my lords, now letter has been addressed by the Deputy Director to the Auditor General Office, my lords. Proceedings has been initiated, my lords.
No. This red petition will not tolerate. When you are going to pay?
I check your instructions, my lords. My
Take
colleague.
instructions.
Please, I check your instructions.
Give us the time limit and dispositive.
I take strict.
Learned advocate, learned additional government advocate, Mr. Raghavendra files memo, along with which produced is the copy of communication dated 11/3/25, which indicates that the proposal is made for payment of the benefits to the petitioner as directed by learned single judge in his order dated 3rd September 2024. Full stop. The lethargy on part of the respondents in compliance of the orders of the court in not paying the benefits to the petitioner. Cannot be permitted in the circumstances. Learned additional government advocate shall take a specific instruction as to within what time the benefit shall be paid to the petitioner. Full stop. Failing with, a stern view will be taken. Stand over to when? 26?
Please.
26th of April.
Not after vacation.
After vacation.
Because
Then
they are
we will
processing, so it takes some time. Therefore, let there be date, my lord. In the meal, they will do it. They are well aware of the date of the contempt proceedings. In the meanwhile, they will only update the developments, but they are not, my lord, doing it quickly. Therefore, your lordship may kindly.
We change the gear and you apply the brake.
No, but they forwarded to the AG office. It is beyond their control. Therefore, here commissioner is only made accused. AG was not party. Your lordship may kindly give a
Files
date.
memo, then the learned advocate.
Date after vacation.
On the next date, learned advocate, learned additional government advocate shall take specific instructions as to within what time the benefits will be paid. Stand over to 5th of June. It is expected that
Please.
before the next date, the compliance will be open.
Much.
Obliged.
December 58 is urgent. December 59, Mr. Narendra S.
For petition in this case, my lord.
This is for office objection.
It's a disposed of matter, my lord. Contempt proceeding has been disposed of based on memo filed by the respondents, my lord. There was a direction issued by the Honorable Court to comply as per the memo filed by them within 15 weeks from the date of receipt of the copy of this order, my lord. That was extracted in the IA call for recalling, my lord. Till today, no action has been taken by the respondent 3 and 4. It's a matter regarding the consideration of a representation, my lord. Based on that, my lord, they have filed a compliance memo dating that they are going to issue Hakkupatras in favor of the petitioners herein. Petitioners are the slum dwellers, my lord.
Okay for the respondent, my lord. This recalling, my lord, I'll just find out what has happened, my lord. Latest development. Your lordship may give me 2 weeks time.
6th of June.
Let their direction, because my lords have observed in the contempt petition, there should not be a willful contempt by the respondents. That was observation made by the my lord.
Council is taking.
Please, my lord, a date may fix.
6th of June.
Please, my lord.
Still number 60 is Shilpa Radi.
Lord, identical matters are pending in Honorable Supreme Court on the seniority weightage. The Lordships may have it 2 weeks hence.
My lord, both cases are different, my lord. Here, my lord, this case is not stayed by the Supreme Court, my lord. In this case is totally different, my lord.
Even otherwise on 23rd July. Check. Yes, next.
Number 61.
61 minutes.
Nisha S. Kumar, party in person.
I appear for the accused number 1.
Nobody is there. 24th July.
Minutes. In fact, order is complied minutes. In fact, I have filed a memo also. Please.
Next.
Number 62. Naveen Jain.
Accused in this matter, my lord. Kindly have it after vacation in this matter.
After vacation, 25th July.
Number 63.
And for the complaint, regarding the maintenance case, my lord, this is.
Yesterday I filed affidavit, my lord, but not put up.
50,000 rupees per month.
Yesterday I filed affidavit, my lord, but not put up.
See, now they are due to a tune of 2,47,000. The matter is that to be finished before trial court. Any excess amount is paid, that will be adjusted before trial court, my lord. Because evidence has to take place. Meanwhile, let them pay some amount, Your Lordship, direct some.
This can be adjourned after.
Your Lordship give any direction. They give some amount.
Let us see.
That will be adjusted after recording the evidence before trial court.
Without understanding what.
30,000 rupees per month was ordered by this honorable court.
What is the matter?
Pardon. Out of 30.
What is the matter?
Matter is regarding maintenance to the wife.
Read it. Read the order, which is under contempt. 30,000 per month.
Yes. Order passed.
It's an interim arrangement subject to orders will be passed in. So this criminal missing application is pending.
Matters are to be adjudicated before trial court.
Now.
Meanwhile, Your Lordship, is because this amount 30,000 rupees per month, there is a due of 3,30,000.
How much it is paid? You have paid?
5 lakhs. 5 lakhs.
Tax is that.
Where is the reply?
School fees is not.
Yesterday I filed affidavit, my lord, but not put up.
My lord, paying school fees is not a maintenance. Apart from that, living there. I filed a judgment of this honorable court also. C12 is the judgment of this honorable court.
Is your affidavit?
In affidavit. I have filed my affidavit, my lord.
This is the affidavit.
2,47,000 they have to pay, my lord. I1 for direction I sought.
Affidavit by details of payment made by accused. So 575, 521 is paid.
Yes, my lord.
That's the school fees, my lord. School fees is not a maintenance. They have to pay apart from that living. Yeah, because she has to pay the rent. She is staying in Bangalore. 2 children are there, minor children.
According to you, what is due?
2,47,000 is due, my lord. If Lordship orders for any order, because the matter is yet to be adjudicated before trial court on 125 CRPC. Meanwhile, if Lordship directs some amount, let them pay the amount, and if any excess amount is paid, that will be adjusted before that. That's what the learned single judge has ordered, my lord.
So this 570 we already paid.
Yes, ma'am.
Now every month you have to pay 30,000.
No, my lord. These expenses and children's education expenses and some of the expenses more.
Every month you are not supposed to pay.
No, my lord.
That's the order passed by this honorable court to pay every month 30,000 rupees per month, my lord.
Only 10,000 is paid, my lord.
No. What is the order of learned single judge? Let us see. Where is that page?
Yes.
Which order you are supposed to comply with?
Page 9, my lord. Type to page 9 of the order of learned single judge.
Yes.
The amount paid by the petitioner to respond herein will be adjudicated in the maintenance to be passed in both the matters. The said maintenance amount of 30,000 includes the rent
per month.
Per month, my lord.
Per month.
Yes. Includes the rent of accommodation of the respondent. The court dealing with the said 2 matters shall not be influenced by the quantum of the interim amendment made by this honorable court while awarding the maintenance. The 125 CRPC is maintained. There is still pending, my lord, before trial court. That should be adjudicated.
So which are the proceedings pending, Mr.?
That case is yet pending.
Which case?
125 CRPC matter is pending.
Which case? 125, we know that.
Criminal case is pending before the trial court. That is
which is that?
Before the family court, my lord.
We know that. Which is that? Come on after.
That's
My lord, could I, with my lord, can I make one submission? My lord, I apologize. My lord had posted the caste certificate matters on 24th. My lord, the learned advocate general has some inconvenience because he's leaving for Supreme Court, my lord, today. If my lord could have this on Monday, my lord, I'll inform Mr. Vivek Reddy, Gurumat. I'm obliged.
Lordship kindly say number 80, my lord, where not they file statement objection for that I have to file by rejoinder. Lordship kindly call it after some time.
Same matter, caste.
Seal number 80, my lord.
A different matter.
My lord, that is not the caste
You
certificate.
can inform.
Yes,
Monday.
Monday. I'm obliged.
Lord, that is 80, seal number 80, where not they file statement objection. Yesterday I have received the copy. Lord, I have to file my rejoinder for that. Lordship kindly call it off.
After vacation.
How much of it?
Give some date. 18th of June.
80.
Your Honor, for writ appeal 983 of 2024, it was listed in CH-5 today. Justice K.S. Mudugal wouldn't allow me to speak at all. It has been that way since 2011, 24, the hearing date. Whenever I try to talk, she's averse for me. She wouldn't allow me to speak in the court. And again, repeatedly, she says that I want to dismiss the writ appeal. Even today, when I wanted to move the memo filed under Order 27, Rule 6 of CPC, she wouldn't listen, and she wanted to dismiss the writ appeal. I request that the writ appeal not be dismissed and brought into this court today. And further, Your Honor, the respondent yet to answer for the consent letter, which was due according to the orders of the Honorable Court on 14/12/2024, Your Honor. The respondent has filed a memo for retirement in this writ appeal, and until today, they have not filed again a memo for appearance. So I have filed a memo under Order 27, Rule 6 of CPC for summoning, requesting orders for the appearance of Mrs. Uma Shekhar, Additional Secretary of Legal and Treaties Division, Minister of External Affairs, in this Honorable Court, and answer the court for the consent letter, which is the first step for pursuing justice in my matter, Your Honor. I have been in this court, the High Court of Karnataka, for about 2.5 years for the consent letter, and the Honorable Court has issued the orders, and I'm yet to receive the consent letter. This is the memo, Your Honor. Just show this memo. And further, Your Honor, if orders for this memo for the appearance of Mrs. Uma Shekhar, Additional Secretary, Legal and Treaties Division, I request 1 week's date, but if the Honorable Court thinks that this is too early for her to plan her trip here and arrive within 1 week, maybe the orders, the next hearing with her appearance could be issued for 6th of June, after the vacation, is my humble request. So the file is currently in CH-5.
Your case is before the bench of Justice Mudugal.
She wouldn't allow me to speak even one word, Your Honor. It has been that way since 2011. I have no idea why she would be so.
You also think that you should not be allowed to speak, but we are allowing.
Your Honor, at 2011, she is the one who.
So it is you have to make a mention before the court where your matter is posted.
But then, Your Honor, she would not listen to the fact that I have come here. First, on 2011, there was orders given by her without me doing any mistake in the court. Saying that I have to reappear in front of the party-in-person committee. Then I came here and according to your instructions, I went to Registrar Judicial and did take an entire iteration of going through one more round of party-in-person committee meeting. And after the second meeting, I answered all their questions. And subsequent to that, Registrar Judicial confirmed that now you can actually move the memos and take this writ appeal forward. Only after that, I am again back in Justice K.S. Mudugal's court. But then again, she would not allow me to speak for whatever reason at all. I mean, she just doesn't allow me to speak in the court. Despite me saying that, I have appeared in front of the party-in-person committee a second time. And then it is in my favor. I have already answered all their questions. And I always followed all the procedures in the court. And I maintained decorum in terms of my... And with reference to the knowledge of the legal acumen pertaining to the writ appeal and my writ petition, I have 100% legal acumen detail, which no one else has, Your Honor. And I also mentioned that I'm willing to withdraw the memo filed on 23/9/24 upon the receipt of the consent letter. So when Mrs. Uma Shekhar comes here and she would address the court about the consent letter and I receive the consent letter, we can move to the prayer which is filed in the memo of the writ appeal, Your Honor. And then I can also walk through all the interim prayer relief in sequence when Mrs. Uma Shekhar is here upon the appearance.
Whatever you have spoken is irrelevant for us. Yes, sir.
Your Honor, I request the file be brought to this court and it not be dismissed.
I am not the Chief Justice of everything and every person. I am Chief Justice to myself only, nobody else. So
Your Honor, I mean, without your intervention, I have this apprehension that, I mean, this writ appeal would be
we
dismissed.
don't intervene unless the matter comes to us. That is the practice of the court and mechanism of the court of law. So you need not, you mention wherever a matter is there, not before the first court.
I'm going to make this one last attempt with in CH-5, Your Honor. But I would request that if Justice K.S. Mudukal forces that it be dismissed, I'm going to request that it be posted here.
I am Chief Justice of nobody, Mr. Party in person. So don't now go on mentioning the name of Honorable Judge in the High Court. Please restrain yourself. When we give you hearing, audience, it doesn't mean that you should speak anything you like, in any manner you like, and anywhere you like. Right?
Number 63.
Yes, this 30,000 per month.
This is an interim arrangement made, my lord. Of
asking which proceedings are pending.
The matter is which is pending.
77 of 21.
Yes, criminal miscellaneous 810 of 23 is pending for the third additional family court.
77 of 21.
These matters have been transferred from Tumkur to Bangalore, madam.
Which is the number of
family code? 810 of 2023.
Which one?
810 of
810. Criminal miscellaneous number 810 of 2023 is pending.
10 is pending.
Pending before the family code. And another petition under DV Act in CR Miss 204 of 2023.
204.
Yes, my lord. Is pending before the Honorable First Traffic Court.
First Metropolitan Magistrate Court.
Two petitions for main.
So we dispose of this.
Yeah, we have complied all, my lordship,
If some interim arrangement is made, my lord, because that what the learned single judge has written, my lord.
While disposing
the amount is paid because the 5 lakhs which they have paid, what they are showing, that is towards the
adjusted in the process.
That is still evidence has yet to be commenced. Matter is posted for evidence on 6/6. Even if they pay excess also, that will be adjusted.
My lord, one submission in this matter.
It will be adjusted.
From order. Yes.
One submission. Lordship, may kindly peruse page number 9 in the order, my lord. In this first page, my lord, page number 9 in the order, my lord, here it is 30,000 interim arrangement has been made, which I am complying. In the meantime, second para, my lord, there is an order to dispose of the petition in 6 months from August 2023. 19 months they have dragged on the matter.
The matter was
Next,
transferred
my
from
lord.
Tumkur.
Next, my lord, last para shall pay the interim maintenance as it is interim arrangement. It comes, my lord, 5,70,000. More than that I have paid for my 2 children, their college going, school going, and my wife. And she is also earning and getting handsome salary.
She is not earning.
Nothing is placed before the court with regard to asset and liability of both the parties.
She is not earning.
Now they come up with the contempt, though I am complying regularly, my lord.
She is getting money.
Cost
from
has to be
his
imposed on them, my lord. I am clear. It is because my memo of calculation.
Let my learned friend show that she is working somewhere. Let she file affidavit to show that. Let him file affidavit to show that she is working.
6 months time granted.
Let him file affidavit to show that she is working. She is making false submissions before the court, my lord.
Arise from order of learned single judge dated 3rd August 2023. Passed in common into
407
petition number 8014 of 2021 and 1434 of 2022. In criminal petition number, insofar as it pertains to criminal petition number 8014 of 2021. Right, that insofar as pertains to dated 3rd August in 2 petitions, whereby the learned single judge has directed the petitioner respondent herein to pay the maintenance as
It is
indicated
interim arrangement, my lord.
every month.
interim arrangements till the disposal of 125 proceedings.
That's all.
I'm sorry.
Dismissed. We adjusted the amount paid by you, 5,75,000, we adjusted.
that is
in
all.
the-
Yes, it is.
See, the
placed
amount
before
which
the
has been
court also.
paid is only the school fees.
It is
madam.
over now.
That is
No,
school.
no dictation of order will be here, no interruptions. Otherwise, we will not be able to dictate the order if you go on speaking and arguing, even while the order is dictated.
So other
One of the
contents-
best habit to be inculcated by the lawyers is not to interrupt when any judge dictates the order. That is more true before this court. Yes, next. It's too much. Every time I'm telling and every time you are interrupting, not permitting to dictate the order. It breaks the chain of the thought. You suffer, you people they suffer. We have no difficulty.
It's a intense case, my lord. That's what I have asked. Others to-
The contempt is closed. The amount of 5,75,000 paid, it is to take a note of. Rest of the things should be adjusted in the proceedings that are pending before the
Other
law.
case, other contention to be kept open, my lord. Let the other contention be kept open.
We have not
Contention.
closed anything except the order here, dictation of the order, because of interruptions. Everything is open. Yes, next. What is the number? This adds to the work there. 63. Yes, next.
Yes. So pass over matter, seal number 5.
64, next.
Lord, appearing for the petitioners.
This can wait.
No, that's- On the previous occasion, the BBMP had undertaken to file the status report in terms of collection, transportation of domestic.
They have to file the reply.
BBMP has to file.
My lords, appearing for BBMP, respond number 2. My lords, we seek some time. My lords, actually, my senior was supposed to make some submissions today, but he had to run after.
But have you
lunch.
filed reply?
Yes, my lord.
Have you filed reply?
My lords, we have filed the reply.
Have you filed reply?
Yes, my lords, we have filed the reply.
After vacation.
Any date, my lord? Any
Tell the date. Tell your date. Tell date of your convenience.
Date in June, my lord? Any
June,
date?
naturally June. 23rd June. Yes.
Seal number 9. Mr. Gaurav GK.
Second look I asked. Nothing is. Then we'll list it tomorrow. Where is the council? Yes, madam.
Seal number 5. Seal number.
You're for Prashant? Then there is an order passed on 16/12/2024, which required you to file some report.
Yes, my lord.
Is it filed?
No, my lords, that report is
Fine.
not filed. My lord, that report is only supposed to be filed by us.
Pardon?
My lords, that report has not been filed.
Why it is not filed? Why it is not filed?
My lords, my senior was supposed to submit his submissions.
Find out from your senior why it is not filed tomorrow. Only for that purpose.
Yes, my lords.
Tomorrow at 2:30 we'll take up. At 2:30 we'll take up seeking your answer why it is not.
Seal number 9. Mr. Gaurav GK.
Go to
18th June.
18 June. 10, Mr. Gaurav GK.
Both. 10 is different, both 18/6.
Serial number 103, it's a withdrawal of writ appeal, Mr. Aditya Chatterjee.
Appellant in this matter
Yes.
may be permitted to withdraw the appeal.
Serial number. Aditya Chatterjee.
No, it's Rishabh Desai for Aditya.
Learned so and so appearing for Aditya Chatterjee for the appellant. Invites attention of the court to the memo of withdrawal, memorandum of withdrawal dated 17th April 25, which figures on record. In which it is stated that in order to put a quietus to the dispute, the appellant has paid entire amount of tax demanded by the respondents towards property tax, difference of interest, etc. to the tune of which 268, 535, 626. Prayer is made to permit the withdrawal of the appeal. Permission is granted. The appeal is dismissed as withdrawn.
Obliged.
Serial number 104, Mr. Venugopal Rao, party in person. Writ petition PAL.
Prayer in this public interest petition is in respect of conducting investigation into the alleged fraudulent land dealings and financial irregularities in Santinagar House Building Cooperative Society Limited, Bangalore. The party in person, plus the petitioner hearing, is absent. It seems that he is not interested in prosecuting the petition, hence dismissed for want of prosecution.
105, Mr. Tejas N, it's a withdrawal of commercial appeal.
Appeal for appellant, my lords. The matter has been settled, my lords, so we have paid the entire amount before the executive court.
States that the parties have settled the disputes outside the court, to further invite the attention of the court to memo of withdrawal dated 14/4/20, filed by the appellant, whose opinion of the statement and the memo filed. The permission
amount,
is
my lords,
granted to withdraw the appeal. The appeal is dismissed as withdrawn.
Court fee, my lords, we have paid, deposited 1 lakh.
Yep. Since the appeal was withdrawn without effective hearing.
For the respondent, my lords.
Yes.
We have duly received the amount, my lords.
Pardon?
We've duly received the amount from them, my lords. The matter has been settled.
Matter has been settled. She's making mention, my lords, matter has been settled.
So any difficulty if he withdraws
No,
the,
no, 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 my
you won't have. Since the appeal is withdrawn without effective hearing, the office shall permit the refund of the court fee if applied for by the appellant.
Please.
This is 106.
And,
Sanchan Jai.
My lord, the petitioner had filed form number 7A before the respondent Tahsildar. My lord, they have issued a memo and given an endorsement saying that the application is not available from the records on the land grant file. My lord, and also the second reason they have assigned is, my lord, in that survey number 200/1, in which the petitioner has sought for 14 guntas of land, 8 acres of land has been mutated in the name of Pattana Panchayat, the local authority. My lord, my humble submission is the petitioner has sought only 14 guntas out of in the said survey number 200/1 there is 10 acres 7 guntas. Even assuming 8 acres has been granted to Pattana Panchayat, mutated in their name. But annexure C in the original writ petition, my lord, is my application for grant dated 28/4/1999. And the writ of mandamus was filed by the petitioner seeking consideration of that application dated 28/4/1999. There is an endorsement saying that it has been received by the Deputy Commissioner's office regarding application for grant under form number 7A. And hence that endorsement explanation is not proper. That would be my.
You challenge it. You wanted to challenge. While passing order dated 8/4/25, it was recorded by a statement made by learned government, additional government advocate, Naveen Chandrasekhar, that the endorsement was issued by the competent authority, which was in compliance with the directions passed by learned single judge.
Dated
by order dated 27th October 23, learned single judge
27/10/23
directed the consideration of the application filed by the petitioner at the hands of HNDS. Respondent 3, in accordance with law, within stipulated time. Full stop. The endorsement now figures on record, filed along with the compliance memo. The said endorsement dated 17/3/25 provides that the claim of the petitioner is rejected as application for form number 7 capital A under the Land Reforms Act 1961 has not been filed, was not filed in the prescribed time. Full stop. The consideration of application of petition. There is the above endorsement marks consideration of the application of the petitioner. Therefore, the direction is complied with. The contempt proceeding does not survive. They are disposed of. Paragraph. However, it is clarified that petitioner is at liberty to challenge the aforesaid endorsement dated 17/3/25 in independent proceedings in accordance with law, in respect of merits of which this court does not express any opinion. Full stop.
Obliged.
Number 107, the Maitri Krishnan.
They were all the Supreme Court orders, because this is with regard to manual scavenging prohibition. And in this regard, there are a series of recent orders passed by the Honorable Supreme Court. Compiled all those orders. I'll serve the government.
But we'll take up after vacation.
But I wanted to put all the orders. There are about 5 orders. They are all compiled. Any date after vacation is given. And if the government could at least, in terms of these orders, submit some compliance, my lords.
Lords, we have already filed compliances pertaining to the directions of the Apex Court and also the direction of this Honorable Court, my lords. For those compliances, no rejoinder has been filed. So we are in compliance of all the directions.
We will file a
If there is any rejoinder, if there is any rejoinder and anything we have not complied, my
We'll do
lords,
the
we will
same.
place it on record.
We'll give a response.
This Balram Singh is still pending.
Please. In fact, it is now listed day after.
And it's a continuous directions we are
So 19th of June.
Seal number 108. Ravindranath K.
My lord, this is pertaining to that setting up of a cow slaughter near the airport. Last time, your lordship may kindly recollect.
No, Lord, I have an update. In fact, we took the measurement. It's beyond 10 kilometers. Beyond 10 kilometers.
So it is within permission.
So which means that our NOC is not required.
But,
I have filed a report to that effect.
Lord, only two requests I'll make, subject to your lordship's monarch, sir.
You are appearing for.
My lords, I'm appearing
He's
for
for the
respondent
private
number 13,
respondent
who is the holder of the license, my lords, for running the slaughterhouse.
Lord,
Slaughter.
Please, my lords.
Lord,
I'm the licensee.
Lord, there is a orders passed by the Honorable Apex Court in Lakshmi Narayan Modi's case. Direction for constitution of the state monitoring committee consists of pollution control board, local government people, two respectable persons and other things. That process is not complied in this case while granting the permission, number one. Secondly, after the orders were passed, there was a direction to the Honorable Chief Justices of all the high courts to nominate district judge, retired district judge, who can head the committee and monitor everything. That process is not complied, my lords. I have placed those two orders on the record. I have already filed it before your lordships. If the pollution control board can confirm whether the process is followed, then, my lords, nothing further survives. Otherwise, my lords, it will have to be examined. May I request kindly take, my lords, the orders along with the memo, my lords, 25th of January 25. In page 25, my lords, of the memo of documents which
But
are.
all prayers may fall down now. Once they are saying that it is.
Beyond 10 kilometers, my lords. That is true. But there are other violations which were there, my lords, which the state.
Which one?
My lord, the permission for slaughterhouse is not granted. The panchayat has granted who have got no power to grant. And there are various regulations, my lords, which the Apex Court says there is a single window agency created, which has to examine everything, my lords, instead of, my lords, coming back to your lordships under 226, requesting for examination of violations. The idea of the Apex Court was that direction is issued across the country. The State House monitoring committees will consist of all 11 members. So if they have complied with that, my lords, nothing further required to be done in this matter. So pollution control board will have to, or the government will have to answer that.
Where is that decision?
My lords, may I request your lordships, along with the synopsis, my lords, I have placed it on record. Last, my lord,
Supreme Court order, where is it?
my lords, in page 25.
Page 25.
Synopsis.
Last hearing.
Last date of hearing, my lords, it was. It is styled as synopsis, my lords. Synopsis with.
English.
Had you given the?
But it is
given?
I have given. Last time, your lordships, in fact, noted that. Extra copies it. May I request kindly take page 25, my lord. These are the interim directions for constitution of the committee. The state to be requested to constitute a state committee for slaughterhouses as follows. Secretary of the Department of Urban Development as a chairman. Department of Health, Department of Animal Husbandry, Department of Labor, Food Safety Commissioner, State Pollution Control Board, Animal Welfare Board, State Police, two prominent persons nominated by the state government, such other officers and experts as may be chosen to co-opt. Then, my lord, the para 4 is the directions. Whether they are establishing new slaughterhouses or old slaughterhouses, everything they will have to undergo this. My lord would kindly take page 26, my lords, Roman 7. In page 26, my lords, of the memo, Roman 7, if your lordships can kindly. To accord a final approval for licensing of state house slaughtering to the local self-government. after compliances of every rule and notification, they have to, my lords, recommend for granting of the permission. Then the final order, my lord, would get it at page 28.
So what do you say about this
Invariable,
monitoring committee?
My lord, I'll seek instructions.
they can file a report if committee is functioning, existed, and if they have done it in this particular case, then, my lords, further consideration may not be really required.
You also?
We also seek instructions. You seek
After
But
20th June.
Obliged.
may I make one, I'm sorry. Any direction to them to place that, because they may not, any direction, my lords.
They have taken, jotted down on the.
I'm grateful.
They have jotted down on the file.
Learned friend should not come and say that it was urgent and therefore, I'm sorry, my lords. I'll go by what your lords.
My lord, my learned friend has read out, my lord, the directions of the Honorable Supreme Court. This I will quote in my email and then I'll seek for a
But my
report.
learned friend is more than fair enough. So I'll go by that. Grateful.
Obliged.
This report is filed.
Cell number 64. Mr. Satish K.
For the respondent 1 and 2 in this case, my lord. My lord, as per the single judge's order, we have completed the court order as per annexure R1. We have produced the document for consideration from the Salam court. We have reinstated the petitioner on 1/8/2024, my lord. I placed the records. Hence, the proceedings may be dropped, my lord.
Both the learned advocates,
As per annexure R1 now.
Mr. So and so for the petitioner and so and so for the respondent, are added that annexure R1, which is office order dated 1/8/24, based on record along with the compliance affidavit, amounts to compliance of the directions passed by a single judge, which are subject matter of the present contempt petition. In that view, nothing survives in the present petition. It is disposed of, is not survived.
Much obliged.
Cell number 65. Mr. Vijay Simareddy.
The order of this honorable court, my lord.
What is it?
No, the order of this honorable court, my lord, is at page number 11, my lord. This has not been considered by the BBMP, my lord.
Page 11.
Relevant page is 12, my lord. The grievance of the petitioner as per representation dated 31/1/2018, my lord, annexure V, is that the respondent BBMP has not paid the salary due to the petitioner.
My lord, it has been complied, my lord. I have filed in affidavit. The salaries according to that direction, my lord, has been paid.
Now it is complete.
Cleared.
No, my lord. This is the representation, my lord. This is the part of the record in the earlier court, my lord.
My lord, the direction was, my lord, to pay the salary for the particular period. My lord, accordingly, my lord, the inquiry was held and
representation,
he
my
was
lord.
exonerated, and thereafter, total amount of 8 lakhs has been paid.
That is the representation, my lord, dated 31/1/2018, my lord. In this representation, my lord, it is clearly stated, my lord, even the pensionary benefits due to the petitioner.
So, memo is there.
This is the representation, my lord. This is the representation.
This is the
honorable court, my lord,
subsequent representation, my lord, wherein he wants the retirement benefits, my lord, the pension to be settled. My lord, that was not the direction, my lord. My lord, I have informed them, my lord, that the pension also should be settled. The direction of this honorable court has been
but they have not
complied.
released, my lord. Till today, they have not released that pension benefits, my lord.
My lord,
That is the request in our representation before this honorable court, my lord. Translated copy is also placed before Lordship's minutes.
As regarding the pension, my lord, I have informed them, my lord. They said we need some time. We will calculate and settle the pension also.
That's why till today they have not settled the mandate. That is our grievance before this honorable court.
The difference of wages, my lord,
That
8,63,000.
This representation was made after our retirement only minutes. The petition was also filed after retirement only minutes. The pensionary benefits have not been settled till today, my lord. We retired on, complainant retired on 31/12/2017 minutes. Till today, they have not released the pensionary benefits.
My lord, the direction is, my lord, to pay the salaries, my lord, because the charge sheet was issued, inquiry was to be conducted. All that has been conducted, my lord, and he was exonerated, and thereafter, my lord, the total salary payable, my lord, page 13, my lord, page 12, my lord, the respondent BBMP has not paid salary due to the petitioner from October 14 to June 15. Therefore, I am of the view that the respondent shall consider the representation and the petitioner wherein in outer limit. My lord, my affidavit, my lord, I have filed and the amount has already been transferred to his account, the salary.
That
Now
is
my
only
learned
salary,
friend, my
my
lord, he is asking for this pension, my lord. That also I have told them, my lord, in view of this, my lord, that has to be settled. And your lordship may give us some time, my lord, I'll ask them to settle the pension also. My lord.
Why you keep pending?
They have not paid minutes.
Then it's not part of.
True minutes. In our representation, it is clearly stated minutes. It is our request, my lord.
When you will.
Lord, it may be called after vacation, my lord, I will.
10th of June.
Oblige.
Grateful.
10-6. Number 66, Nagarajan. 66.
Orders have been compliant with, madam.
The respondent has partly complied the learned single judge order, my lord. I sought for a police protection to construct the compound wall. They have denied the same, my lord. As per the annexure L, my lord, I have produced in a WP. I sought for a police protection to construct the compound wall, my lord.
10th December 2024, an affidavit is filed by my orders by the.
They have partly complied, my lord. They are not providing protection to construct the wall, my lord.
May kindly see paragraph number. The area models where they had obtained the stay. Even that has been vacated, and 25/3/2025, the boundaries have been fixed, my lords. Since there is an encroachment area, my lords, there is a civil dispute. In view of the same, the compound rule cannot be put up, my lords.
Boundaries has been fixed, my lord.
Boundaries are fixed, my lord.
has been fixed. So for that only I wanted to construct the compound wall, my lord.
Lordship, may kindly see the impugned order, page 3, my lords.
Specific direction to provide police protection.
Yes, madam.
I'm seeking for a police protection, my lord.
Under which direction?
Under learned single judge order, my lord, as per the order.
Show us.
Yes, my lord. It's there in Annexure A, my lord, page number 11.
Court is directed to provide police protection.
Yes, my lord.
Read it.
Consider the representation.
Read it.
Page number 13, my lord, order. Issue a writ, order or direction in the nature of writ of mandamus directing the respondents number 5162 consider the representation dated 23 to 24 and provide the police protection to fix the boundary in land bearing number so and so, my lord. As per my representation, I given a representation to construct the compound wall, my lord.
Where is the direction of learned single?
Direction to consider the representation, my lord.
In representation, you stated about police protection.
My lord?
In representation, you stated about police protection.
Yes, my lord.
My lord, as per the direction issued by this honorable court, my lords, with the help of the police protection, boundaries are fixed and complied with the order, my lord. And we have found there is also an encroachment in the boundaries. They have to resolve that dispute, my lord. We have fully complied with the orders passed by this honorable court, my lord.
My lord, what happened in this case? In the year 2016, the neighbor landowner family member has committed suicide, my lord. That has been blamed in the name of the petitioner and filed the FIR against the petitioner, my lord. There are 4 complaints against the petitioner, my lord, when he entered the land, my lord.
There is no direction, madam.
My lord, consider the representation, my lord. I have given a representation.
That we have done it, my lord.
That they have done.
That we have done and complied with the orders.
No,
of
they
the-
have only fixed the boundaries, my lord. I wanted to construct the
That is
wall.
the directions given by the honorable court, my lord. We have done, we have fully complied with the orders, my lords.
No, my lord, partly compliant.
Boundaries are measured.
Boundaries are fixed for all the 4 survey numbers, my lords.
All the
4 survey numbers. There were 4 survey numbers to be boundaries to be fixed, my lords.
4, 7.
4 survey numbers. That is survey number
34 bar
34
2,
bar 3, 34 bar 2,
32.
44 bar 2, and 31 bar 3. For all the said 4 survey numbers, boundaries have been fixed with the help of the police protections, and we are compliant with the orders of this honorable courts, my lord.
Not only the representation, the prayer in the writ is compliant. There is no direction. This protection, they have an answer. Saying that there is close it.
You decided the representation.
Hello?
Representation is decided.
It's considered, my lord.
Where is that?
It is acted upon on that representation, my lords. Lordship, may kindly see, my lords.
2911.
Please, my lords. In terms of the representations, the
You
authority.
got that? Page 25.
Please. They have written only measurement in the 6th line, my lord, and requested to pass temporary stay order till demolition appeal measurement is completed. Hence, it is hereby informed that temporary stay order. My lord, after filing this contempt petition, they have passed this order, my lord.
I make one submission, my lords.
Now it is complied with.
Complied, my lords.
No, my lord, partly they have complied, my lord.
What
The stay order has been issued after filing this contempt
You don't
petition, my lord.
presuppose that consideration means in your favor. It is processed and something is done. That's all.
That we have intimated to the ADLR also, my lord. We have filed the contempt petition. Also, they have passed the
The
interim
writ
order.
petition was this. Learned single judge of this court by order dated 18 June 24, while dismissing the while disposing of the writ petition, directed respondent 5 Superior Police to consider and pass orders on the representation dated 23 to 24 of the petitioner. That it to be full stop. It is regarding what?
Construction of compound wall, my lord.
The grievance of the petitioner is that the police protection is not being provided. Full stop. The direction do not passively contemplate such direction to be acted upon. Just such direction to be carried out. Full stop. In the circumstances, contempt could not be. It could not be said that the contempt is committed by any of the authorities, much less a willful contempt. Contempt proceedings are not required to be continued any further. The petition is disposed of as not surviving. Full stop. The submission is that the police protection is not provided. As noted above, the court does not find any such positive direction which could be made subject matter of contempt. Full stop. While closing the contempt proceedings, however, it is provided that it will be open for the petitioner to renew the request for police protection before respondent 5 to be considered in the facts of the case and strictly in accordance with law. Right. Petition is disposed of in the course.
Number 67, Mr. Devraj.
Respond to your lordship.
I'm appearing for the complaint in this matter, my lords. My lords, we have filed this contempt petition based on the writ petition, which has been allowed by the Honorable High Court. So on 25/4/2024, my lords, this Honorable High Court has allowed the writ petition which we had filed and ordered to pay a sum of rupees for 4,42,758 rupees, which hasn't been done till date. We have sent a representation letter also along with the order copy to the accused, and still there's no action been taken. I mean, there's no remedy given to us, my lords. That's why we have filed the contempt petition.
Your lordship, you have preferred appeal, your lordship, in this matter. So have it after vacation, your lordship. We will it's for office objection. We'll comply it, and a date will be fixed, your lordship.
My lords, if so, then kindly post it on 8/7, my lords. There's a similar matter on the same day, so kindly post it on 8/7.
Please, your lordship.
The complainant said that this proceeding may be posted on 8th of July.
Much all.
Request to be listed on 8th of July.
68.
Petitioner
Mr. Shankar Vaidi.
That in spite of sufficient opportunity, my lords, the respondent my lords failed to comply the order of the single judgment.
My lord, we have filed the wakalat for accused number 2 and 3, my lord. 2 weeks time may be given to file the affidavit.
I will give, but when you are going to complete the inquiry?
Just today we have got this contempt.
When you are going to complete the inquiry?
No?
When you are going to complete the inquiry?
Sometime
1 year has passed. No time limit.
26. Second one. Clear. Close number 20. We have fixed 3 months.
In the contempt petition, my lords, fixed 3 months time, my lords.
I'll seek the information, my lord. Just today we have filed the wakalat. Seek the information.
Today we are in April, May 24. So 3 months time was granted on January in September 24. So
I'll seek the information, my lord. Just today we have filed the wakalat, my lord. I don't.
just you file wakalat. Learned advocate Mr. So and so is permitted to file his wakalatnama as prayed for. Also, the petition shall come up on 2nd of May, on which date learned advocate will apprise the court about the progress of the inquiry. About the progress of the inquiry. Telling which who is remain present. Just brushing aside the court's order. Who is conducting inquiry?
That's Panchayat Development Office and EO, my lords. EO has to conduct inquiry, my lords.
Unless the satisfactory progress is shown in compliance with the directions of learned single judge, the court will be compelled to pass stern order asking the respondents to personally explain the contumacious CONTUMACIOS conduct to be listed at 2:30.
Oh, that's
29th, not second, 29th.
29th, 2:30. Number 69, Mr. Vijay Kumar.
The orders have been complied, my lords. The complainant has been appointed police constable.
Will take instruction from my client, my lord, whether this may communicate to him or not.
No, communication to is the communication to your client.
My lords, I apologize, it's in vernacular language.
Learned additional government advocates in the promulgation. Tenders copy of endorsement.
My lords, it's appointment order.
Appointment order dated 21/4/25, which reflects that the petitioner is given appointment as constable. Full stop. The same, which is in vernacular language and explained to the court in English about the contents and the providence thereof. Is taken on record. Contempt petition does not survive. Disposed of according.
This number 70.
For the respondent number 3, not permitted to file a memo for enclosing the list pending.
Lord, pursuant to the previous order, my lord, a report has been placed by the committee, my lord, stating that there are no pending cases as on today. The 2 applications that were pending as on previous date of hearing, they have also been disposed of. As on today, there's nothing pending before the committee, my lord. All cases have been disposed of.
There are 68 cases are pending.
I'm placing the communication, my lord.
Lord, the 2 applications which we had filed, Your Honor, the committee has considered and the inquiry is completed, Your Honor.
Completed.
And even orders have been passed. And there's another direction by your lordships to the BDA to submit any other further applications or files to be sent back to the committee for consideration or to meet the ends of justice as directed by the previous coordinate bench of this honorable court, Your Honor. So BDA today have just served me a memo which says that another 68 files are still pending to be sent back to the committee, Your Honor.
Pending.
Pending with the BDA, not with the committee.
Pending
As
with
on
the
date,
BDA to be
committee,
sent to the committee, my lord, not before the committee. Before
as
the
on
committee,
date, the
nothing is pending.
As on date, the committee has completely concluded all the pending.
But now we had revived the thing only for your individual purpose. If
My
anybody-
grievances as per your lordship's order is met with, Your Honor.
The report says that no matter is pending.
Nothing is pending.
Nothing is
Committee,
pending.
there
with
is
the
no.
committee.
Everything has been disposed of, no case is
Things
pending.
pending before BDA, then
The BDA, only thing is that BDA will have, to, as per the directions of this previous order of this honorable.
Yes, ma'am.
what do you say?
68 cases are pending. So,
As per their contention, 68 more cases have to be conducted into inquiry, which needs to be sent back to the committee.
You were supposed to send pursuant to this order. You are keeping.
Lord. It has to be forwarded to committee mail. 67 cases are.
The complaints grow in number when they are with you.
68.
68.
Mr. Counsel, when the complaints are lying in your cupboard, they grow in number
No, ma'am.
automatically. We don't know about your cupboard and silo. Yes. Do they go increasing automatically?
There is no.
Only thing is that I can make a suggestion, my lord. If the BDA are ready to send it, it will be well and good. Or else it will be again burdened by your lordships again. We, like allottees, again coming back to your lordships and troubling your lordships to pass orders. So only if the BDA are going to make any positive directions.
Had said that memo, my lord. There is a 68, only 68 cases are pending.
Only 60.
No, yes, no other cases.
Only 60.
Yes. It has to be forwarded to committee and committee has to decide.
So it will take how many, what time will take in disposing of those petitions?
Only 4 weeks time.
Not possible. Not possible.
Committee,
my
no.
lord. They have to
We have
issue
to-
notice and they have to conduct an inquiry proceedings. 4 weeks may not be possible.
We have forwarded to committee, my lord. Within 4 weeks we have.
No, again, the question will arise is, my lord, once they send the files to the committee, committee will have to issue notice, then conduct inquiry. So it might take much more time, Your Honor. If they take 4 weeks time,
It will take minimum 4 to 6 months.
yes, ma'am.
Please, my lord. Please, my lord.
4 weeks for them to send the
Inquiry, my
files,
lord. They
the
have to
committee
furnish-
another 4 weeks. Totally maybe another 2 more months it will be, as per my knowledge goes, my lord.
Notices have to be sent to the site owners, my lord. They have to furnish all the requisite documents, which an inquiry will be held based on that.
It all depends upon the BDS fast actions, my lord.
Now the committee is ready to get extended.
Committee's tenure is completed only by your lordship's order. Committee's tenure was extended till today, Your Honor.
24.
It was extended to consider the 2 applications filed by my learned friend, my lord.
Now there are more 68.
Now they are coming up with another 67 applications.
Within 2 weeks I will
Only
forward.
68 is there, are you sure?
Please.
Sure.
Only 68 is there. Or there are more.
Yes, my lord. Yes, only 68, my
You
lord.
count-
There is no pending case.
You counted yourself.
My lord.
You yourself counted.
Yeah, no, my lord. I verified the BDA, my lord, allotment section. And so they sent the list for 68 pending cases.
PDA is very slow. You are very fast. PDA is very. What do you propose to do now? Tell us.
We have, we have forwarded to committee, my lord, within 2 weeks.
Within 2 weeks.
Yes.
Lord, the extension has to happen by way of an order from your lordship, my lord.
Yes.
As only for the limited purpose, the extension was granted earlier, previous order. Now it has to be extended further to consider the application. Otherwise, each one of the applicants would approach this court, my lord, for reopening of
That's
the.
what is right. Again, there will be.
Correct, my lord. They will again approach this honorable court for necessary
flow
orders.
of litigation.
Oh, I'm sorry,
Very
my lord, I'm sorry. I did not mean that way. my lord.
No, you are right. Where is the question? We are
Yes.
appreciating that. Not any other.
Definitely, my lord. When people approach our officers on this, we need to trouble your lordships
Otherwise,
with
it has to
filing
be
application.
reconstituted again.
68% will feel that we are stranded. So we'll pass the order.
Lordship may pass
But
the
you
order.
want to take
Line for disposal of these cases, my
two
lord.
more 11. We'll
Please,
pass the order and dispose.
Please.
Only my request, my lord, if the BDI are ready to come out, what is the time frame they required to send the files? Then only the committee will be able to act upon you.
He is saying 2 weeks.
2 weeks.
Yes, my lord. Tomorrow, my lord.
And you work for whole night today and search out more applications. We will take instructions. Then we'll.
I'll take it.
Definitely.
Number 71, Mr. Praveen Kumar N. It's a writ petition PL.
Yes. 71.
71. Mr. Praveen Kumar.
That uncovered drain. Nobody is there.
My lords, for
14
respondent
minutes.
number 3 and 4.
Number 6, my.
It is 13%. Learned advocate is not present. The writ petition, which is public interest petition, belongs to the year 2014. To stop. The absence of learned advocate is not welcome, in as much as the old matter has to be dragged further to a subsequent date. Full stop. However, in the larger interest of justice, stand over to 19th of June.
'72 is adjourned. Seal numbers 73. In writ petition PIL, Mr. Nikit Bala.
So nobody is present in view of the petition. 73. Stand over to 28th July.
Seal number 74. Mr. Bipin Negde. It's a PIL.
Will it serve? Will it survive? Does it survive?
My lord?
Will it survive?
My lord, yes, I'll file the report. My lord will have to just peruse the report and then close it. And if in case if any action is to be taken, if my lord were to, my lord, I have written my lord to them to give me the English translation of the report, but I haven't received it.
Let it go.
Finally, if my lord were to grant me till after.
20th June.
Obliged, my lord.
Seal number 75. It's a writ petition PL. Smriti Vaishali Hegde. 75.
Dispute. Why it is come? Who will appear here? You are supposed to file some reply, reports which is not filed.
Lord,
Order was passed in 22.
Lord, 75, I'm not a party there, my lord.
No, you are a party. 1 second. No, you are not. You are not a party. The petition was this petition was previously disposed of as per order dated 27/7/22 passed by the division bench. While disposing of the petition, it was directed that the action taken report shall be filed by the jurisdictional assistant executive engineer before the court on or before 10/10/22. It was further provided that if such report is not filed, the matter may be registered on 19/10/22. And if the action taken report is filed and which is shown to be deficient, liberty was granted to the court to move the application. Full stop. The endorsement, when the petition again comes up on board today with an endorsement that this report is not filed. Full stop. In the facts of the case, court considers it fit to issue notice to the respondent BBMP and Bangalore Mahanagarpalika to respond as to why the direction is not complied with and the report is not filed. The matter shall be next posted on 30th June.
Number 76. Shailesh, yes, Katari.
Not appear for the petition. 2 weeks time may be granted. 2 weeks time.
24th of June.
So number 77, so petition PA, Mr. Shivram.
Yes, I appear for petition, my lord. The respondents, my lord, 8 and 9, my lord, have not filed their objections, my lord, though they were served. And our case is,
May I make one request, my lord? My lord, here the Rajiv Gandhi Rural Residential Corporation Limited has to be made a party because the government has created this corporation, my lord, for distributing sites, the sightless people under the Ashraya scheme. So they will have to be made a party, my lord. My lord, the Rajiv Gandhi Rural Residential Corporation Limited.
that is, they are not the parties, they are not allotted the site, your lord. It is the site allotted by the Tahsildar, your lord.
No, Hakku Patra is
Hakku
issued
Patra has
by
been
the,
given.
that is because the beneficiaries were identified by Rajiv Gandhi Rural Residential Corporation Limited and the Tahsildar just inked the Hakku Patra.
Yes, I will implead, your lord.
Law and advocate of the petitioner seeks to implead Rajiv Gandhi.
Rajiv Gandhi Rural Residential Corporation Limited.
Rural Residential Corporation Limited as party respondents.
My lord, Sumana Badliga appears for the corporation, my lord.
Full stop.
The permission of the court, my lord, I can implead, my lord, I can serve copy on the others.
Amendment is permitted, cost title shall be amended. The petition shall be listed on 11th June.
I may be permitted to serve the copy, my lord, and also permit me to amend the cast title itself, your lord, to avoid further delay.
My lord, the name of Sumana Baliga may be shown, my lord. She appears for the corporation.
Yes.
And Sumana Baliga for additional government for the respondent. Yes, next.
Seal number 78.
Obliged.
Mr. Nataraj HT, petition PA.
We have filed an,
Petitioner has-
IA, my lords, for dismissal of this PIL. But I am the 12th.
To be permitted to file a counter, my lord. They filed an application yesterday.
But I must bring to lordship's notice, my lord, I am the 12th respondent. I lost the recent assembly election. He is the one who contested elections. All that has been suppressed. He is an active political worker. He contested the elections and he succeeded in that cooperative elections. Now he wants my house to be demolished on the ground that it comes in the buffer zone. Now, my lords, there was a Lokayukta report they had filed. They had filed a complaint before the Lokayukta. Lokayukta obtained report. The report says buffer zone is not identified. No, 1 second, sir. You have suppressed all these facts. Therefore, we have filed this application. Lord, kindly see the photographs, Lord, Lord, kindly see our application which we have filed. He contested the election. Lord, this kindly see annexure B, Lord, which is in Kannada. Translation is annexure at page 31. This gentleman Naveen R, petitioner, he set up by the present MLA who defeated me. But kindly see page 31, annexure B. Which page? I'm sorry, page 31 of my application, which is application for dismissal of the application is one of 20.
One of 25.
Yes. But kindly see page 31. An appeal to make the following 4 contestants as winners by casting your valuable votes during election held on 18/1/2020 Saturday, who have contested as candidates supporting Dr. MC Sudhakar during the B category member election so and so. This Naveen R number 3 is the person who was defeated. For then we have produced some photographs at annexure C to C. So they were all members of the same team. Annexure D at page 33 is the Lokayukta report. The Lokayukta report says that we cannot identify the buffer zone at page 42. Now, Lords, I may only point out but I have constructed a house in my village. I may just point out, Lord, kindly see the water body and this, kindly see the distance between what. And it has been about in existence for several years now. Lord. And just because they share a political rivalry, they want it to be demolished. But my request is section 15 of the NGT Act, besides all this, provides them a remedy regarding buffer zone, because a buffer zone has to be identified, evidence has to be left. Now they want the direction to be issued. And apart from the suppression of fact, has grave consequences, misusing the...
My lord, is that right, my lord? Because application is filed, the application office raised objection. I need to file an objection, statement of objection. It is not the petitioner, number 1, Naveen, they make an allegation. There are other 2 petitioners, my lord. The office has raised the objection. It is not complied with rule 2 of the writ petition, writ of public interest litigation, my lord. Para number 4, we have categorically stated what is the petitioner number 2 and 3. Therefore, we need to emphasize all these things by way of pleading, my lords. Let me file an objection, statement of objection to the application filed by the learned counsel for the respondent.
Misuse for political rivalry.
It is the respondent, my lord. The government also approved, government also contended.
Docket explosion already, my lord, because of the pendency of the litigation. Just because, my lord, they lose the election or they win an election.
State government has, no, Naveen is not a MLA, my lord. It's only, he has specifically stated in para number 4, I am the Taluk Panchayat member. I am protecting the only interest of the villagers, my lord. There are 3 petitioners, my lord. Not only 1 petitioner. There are 3 petitioners, my lord, and moreover, my lord, the respondent, state government has filed objection, stating that there is a clear violation of buffer zone by the 12th respondent. May I take your lordship and attention to the statement of objection filed by the respondent, wherein they have categorically admitted to the fact that after inspection of the spot, the 12th respondent, by political influence, changed the entire, my lord, survey records. May I take your lordship and when it comes to merits of the case, my lord, the sale deed boundaries shown, my lord, specifically depicts that both the side there is a tank bund, my lord. West and south, my lord, tank bund. And my lord, for the purpose of taking a permission or conversion of the order, my lord, they changed, they concocted the document, fabricated the document, and may I take your lordship and attention to the statement of objection filed by the respondent, my lord. Para number 4 of the statement of objection filed by the respondents, my lord. Statement filed by respondent number 1 to 4 and 9 to 11, my lord. May I read, my lord, regarding para number 4, my lord? The averments in this para relates to the purchase of 13 guntas of agricultural land by the 12th respondent in survey number 36 for A, Munaganali village under the registered sale deed dated 25/1/2012. The same is a matter of record. It is true that the boundaries in the registered sale deed dated shown as east by and west by tank bend, north by road and south by tank bend. It is pertinent to state that here that sale deed dated so on so survey number is mentioned is 36 of Munaganali and not by survey number 36 estate of Supra. The averment made in this para relates to the filing of application by the 12th respondent and obtaining a sketch by furnishing a wrong boundaries. This itself is a clear, my lord. He furnishes the wrong boundaries. Para number 5, my lord. Para number 5 of the statement of objection.
Kindly see para 5. What is that?
Para number 5, my lord. The statement of objection. The averment in this para relates to the filing of application by the 12th respondent and obtaining a sketch by furnishing a wrong boundaries. The same are matters on record. It is further, it is true that 11E sketch boundaries are mentioned as east by Hissa number 1, west by survey number 59, to the north road and to the south 59. The said boundaries are different. What is mentioned in the boundaries and the registered sale deed dated 25/1/2020-2012. Further, your lordship may kindly turn to the last para, my lord.
Learned friend is skipping all the paragraphs.
No, para number 11, my lord. No. I would like to contend, my lord, because there is a clear violation of, my lord, buffer zone, my lord. May I take your lordship and attention to para number 11, my lord. Page number, state, objection filed by the respondent, my lord. State government. Para number 11 of the objection. Please, madam. It is humbly submitted that despite imposing a suitable condition in the conversion order dated 19/1/2016,
Yeah, I'm not with you. Statement of objection of the state government. So which paragraph you read?
para number 11, madam.
What is that? How it starts?
Madam,
How it starts?
it is submitted that despite the imposing suit, my lord, para number, my lord, may I take your lordship? Para number 5, my lord. Can I take your lordship, kind? The said boundaries are different from what is mentioned in the boundaries in the register sale deed, my lord. My lord, let me place a record on whatever the IA they have filed today. Application has been.
Lord, his argument is on conversion order. He
No,
doesn't
no.
challenge the conversion. Lord, I am sorry, my lord, but my preliminary objection is, but with great sacrosanct jurisdiction, PIL is utilized. Lord, lordships invoke this. These persons, my lord, misusing that sacrosanct jurisdiction, Lord, completely suppress all these facts. Petitioner number 1, my lord, says cherished political ill will as against 12th respondent, contested elections.
No.
Participated in elections. In all fairness, in all fairness, he should have disclosed it.
My lord, may humble submission. Para number
Merits
5.
notes I have produced before your lordship.
Para number 5 of
One
the
second,
petition.
1 second. kindly see my application, which the state also relies upon. But kindly see my application and the annexure which we have produced, the report of the Lokayukta, which went into their very representation, that has been suppressed. Right, page 42. Page 42 of the application which we have filed. Page 42, Lordships may kindly see, this is the report of the Lokayukta. Page 42, running page 42.
Yes.
Kindly permit me to read the last sentence. The technical opinion condition, it starts from that. And in this regard, Lordships may get that sentence. And in this regard, the document submitted by the complainant and in the condition mentioned in the technical opinion condition of the Office of the Assistant Director of Urban and Rural Planning, the condition imposed is that all around the lake, the buffer zone should be reserved as per rules and as per the said condition. In the Taluk Panchayat's commercial layout plan approval, it is seen that there is no marking of lake buffer zone. While submitting this to yourself, I would like to submit that the case is registered. There is no marking of a buffer zone, page 42. Now, this has been suppressed again before your Lordship. But I would still not request, but I'm not saying that no, nothing should be done. If they want to establish a fact, it has to be, I have to be given an opportunity. They file a petition before your Lordship, seek collection of evidence. Either let them invoke the jurisdiction of National Green Tribunal, which is a competent authority under section 15. But let them invoke it. I'm not suppressing all these facts.
Lord, this is the report what my learned friend is appending, page number 55, my lord, which is in Kannada.
1 second. Yes, reserved.
Yes.
Appearance like a standard order. Yes. Reserved for orders. Pura.
My lord, I didn't get, my lord.
Reserved.
Para number 5 of the petition, my lord, may I like to take your Lordship kind attention. Para number 5. That the petitioners may take. No, that's what I want to do. Please, kindly come to para number 5 of the petition, my lord. There are 3 petitioners, my lord. The petitioners have been exposed to the activities in the concerned region through their personal and professional lives. The petitioner number 1, my lord, what my learned friend wanted to say relates to petition number 1, my lord. While filing a writ petition, my lord, it has been disclosed. Petition number 1 is a BCA graduate and also the director of the Taluk Agriculture Produce Cooperative Marketing Society. Marketing and the petition number 2 and 3 are studied up to high school, and they are social workers and resident of Munidanalli village, where the concerned area in this PAL. The petitioners have means to pay the cost, if any, imposed by the dishonorable court. The petitioner has given an undertaking in this regard. My lord, whatever the rules contained in the, my lord, has been fulfilled. That's what my learned friend has been contending, that rules has not been complied. My humble submission, para number 5, after complaints of the rules, then only the matter came before this honorable court, and thereafter notice was issued, my lord. So far as statement of objection is concerned, my lord, it is categorically admitted by the respondent, my lord, that the 12th respondent, during his tenure as MLA, my lord, he has gone to an extent of, my lord, putting up a construction of commercial building, my lord, for a production of plant, that is the RMC plant has been constructed, my lord. That is what, my lord, I would like to rely upon the judgment of Honorable Apex Court. Lord, para number 60, para number 60 of the judgment. State of Karnataka is agreed with the following offending portion of the order so and so. In the lakes, my lord, Roman 1, my lord. Roman 1. In the case of lakes, 75 meter from the periphery of water body to be maintained as a green belt and a buffer zone for all the existing water bodies. lakes, etc. 50 meters from the edge of the primary Raja Kaluways, 35 meters from the edges in the case of secondary Raja Kaluways, 25 meters from the edges in the case of territory Raja Kaluways. This buffer would be treated as a no construction zone in all intent and purposes. This is absolutely essential for the purpose of sustainable development, particularly keeping in mind the ecology and environmental of the areas in question. All the offending construction raised by the respondent number so and so of any kind, including boundary wall, shall be demolished which falls within such areas. Wherever necessary, dredging operations are required. The same should be carried out to restore the original capacity of the water spread area. Not only existing construction would be removed, but also none of the respondent project proponent would be permitted to raise any construction in this zone. All the authorities, my lord, my humble submission, my lord, their representation was made to the Lokayukta also, my lord. Lokayukta also opined that there is a violation of, my lord, 30 within a 30-meter, my lord, the construction has happened, commercial construction, my lord. That too, he started putting up a construction of production of commercial building, production of RMC, my lord. This is what opposed by the local resident because it's the water sources, my lord. It is water sources for the purpose of Munaganalli village. So my humble submission is the objection filed by other side also demonstrate that, my lord, there is a violation, my lord. There is a violation by the, not only violation, my lord, for the purpose of taking an order, the 12th respondent changed the boundaries, my lord. This is what it depicts in the report filed by the Lokayukta, my lord. Can I take lordship attention to the Lokayukta?
Whatever you want us to take, wherever you take, we'll go with you.
No, it's not that, my lord. Merits of the...
Not that, correct. Wherever you take us, we'll go after reserving the order.
May I take your lordship kind attention to the page number 41, my lord.
You read and we'll listen.
In this regard, on 4/10/2023, the Assistant Director of Land Records, in the presence of the Honorable Tahsildar, Revenue Inspector and Taluk Land Surveyor, this is a this is the Kannada, it's in Kannada, my lord, translated into English, my lord. Having personally carried out the spot inspection and sketch and reported prepared, is submitted to the Additional Registrar's Inquiries to Bangalore on 20th/12/2023. As directed by the letter in the reference number so and so, once again, the Honorable Tahsildar, Executive Officer and Taluk and Land Surveyor when visited the spot on 18/1/2024, and the measurement work was done with the survey, the original documents and the land conversion order and sketch. In survey number 36/2, with regard to the extent of 13 guntas, Manugaralli village, earlier in the land conversion sketch given, it is found that there is a difference in the boundaries. My lord, there is a difference in the boundaries. That's what, my lord, I would like to make submission. The sale deed speaks, my lord, so far as the purchase of the property by the 12th respondent with a boundaries which is not there in the report, my lord. My humble submission is, when he purchased some property, my lord, 13 guntas, the boundary what was mentioned which is not there while preparing a sketch, my lord. This is what my humble submission. For the purpose of obtaining a conversion order, he gives a wrong boundaries. This is what depicts, my lord. This is the report. Timaraju, my lord, Timaraju land surveyor earlier given a boundaries, north by road, south by survey number 59, east by survey number 36/1, and west by survey number 59. During the spot inspection found correct to be recorded boundaries, north by road, south by lake place, east by survey number so and so, west by lake place. These are the report, my lord, would demonstrate before this on the court, my lord, there is a lake between the boundaries of the sale deed, whatever the property purchased by the 12th respondent. Therefore, my humble submission is, the person who purchases the property, my lord, giving a different boundaries for the purpose of conversion, he gives a different boundary so as to put up a construction. He obtained a conversion order and put up a construction on the land, within the buffer zone. This is what the petitions are before the court. Now, kindly, final report is, while submitting the above materials to yourself in connection with the land in survey number 36/2 measuring 13 guntas of Moidanali village, Kaspa village, Chintamani during the year 2012, why the said land coding being done, as the boundaries are mentioned in the wrongly, as per the said body, as per the said body sketch, the Taluk and surveyor have also prepared the land conversion sketch and towards the south and west direction, instead of mentioning the boundaries in survey number 39, Lake Place, have wrongly mentioned in survey number 59, and as per the sketch, the land is converted. And in this regard, the document submitted with complainant And in the condition mentioned in the technical opinion condition of the Office of the Assistant Director of Urban and Rural Planning, the condition imposed that all around the lake, the buffer zone should be reserved for as per the rules and as per the said condition. In the Taluk Panchayat commercial layout plan approval, it is seen that there is no marking of a lake buffer zone. While submitting this to yourself, I would like to submit a case registered with the Karnataka with regard to the said matter before the Honorable Court of Karnataka and writ petition number so on so on. This is what the report, my lord. After the inspection, my lord, that's what, my lord. I need to emphasize regarding the case, my lord, because other side filed an application, my lord. I did not get an opportunity to file objection to the application, maintainability application. I wanted to file an objection. Anyway, my learned friend has argued the matter. Even I too wanted to argue the matter. I addressed the argument. They have filed an application for maintainability of the writ petition, my lord. Yesterday they served the copy. I wanted to file a statement of objection to the application, my lord. They wanted to contain something else, my lord, which is not at all.
What is your request?
Please, my lord.
What do you want?
My lord, I wanted to file a statement of objection since my learned friend wanted to argue the matter on merits. Therefore, I stated the merits of the case.
Right now, what do you want?
My lord, I may be permitted to place a statement of objection onto the application filed by the.
Next. We have no remedy. Yes. File whatever you want to file.
Please, ma'am.
Number 79.
For the petitioner.
21st August. 21st August.
79.
Here for the petitioner, my lords. Lords, on the last date of hearing, my lords were pleased to issue notice to the impleading applicant.
How many matters? How many matters? Waste of time. 79.
The notice to the impleading applicant has also been served, my lords. So may be permitted to amend the cause title and bring on record the impleading applicant.
After vacation. 14th July.
Much.
Number 81, 80 is urgent, 81. Srinivas Gowda, it's a PAL of 25,
80,
awaiting service.
80. Nobody is there. 81.
R. Srinivas Gowda.
August. No. 24th July.
So number 82, Shri Vijay Kumar R. So writ appeal.
Not for appellants. Lord, press for 2 weeks time, my lord.
25th July.
Lord, interim order has to be.
My lords,
Order shall stand
my lords,
till next.
my lords, this matter is connected with the writ appeal 1447 of 2024. My appeal is pending and I'm not enjoying the privilege of the interim order. By agreed by this, but the same common writ petition order, I am also.
Common judgment.
My lords?
Judgment is common.
Yes.
Then it will apply to you also.
My lords, my only inconvenience is it's in two pays. A point was raised in reference to there was a violation on my part also. In that particular context, court has that the writ court has passed an order that even my property has to be demolished. Under the circumstances, I come under the gray area of 187, wherein 50% illegality or the violation can be waived off. I am on that particular point. Since there is no interim order in my favor or in my appeal, I crave the indulgence of the court to extend
an interim order of,
For extension, so many,
no extension, it is not, no order was passed in my appeal.
so interim order is extended.
In reference to his appeal, interim order is sustaining. I have not been given an order. I couldn't be heard there. Reason is it was made over to the same.
So your matter is 82.1?
Yes, my lord.
82.1?
Yes, my
lord. Keshav Murthy.
Very correct.
There is no interim order here.
No interim.
And you are apprehending demolition. What is the, what interim order you want?
Interim order that the order of the lower court should not be enforced for the reason that demolition is already there. Notice has already been cast on me.
Since the petition order is against both the petitioner as well as the respondent. So in order to comply with the direction issued by
and
this
82.1, both common order. Stand over to which date we have kept? 25th July, full stop. Since interim order is operating in writ appeal number 461 of 24, the protection is extended also to the appellant of writ appeal number 1447 of 2024.
Great.
To operate till the next date.
Great. Dates.
5th of July.
Number 83. Writ appeal. Mr. Chandrakant Argole.
I'm for responding now. I'm for responding now.
83 awaiting service. Since service is expected to be listed on 21st July.
Number 84. Mr. Mallaya MR.
So we appear for the respondent, my lords.
Mr. Mallaya MR.
Nobody is for the appellant.
For the petitioner, they are not.
Send over to 23rd of July.
Grateful, my lords.
Number 85, state appeal.
I appear for the respondents.
85, my lord, there are 3 appeals in the state appeals in the batch, my lord. The service to the corporation, my lord, is awaited in first matter.
In services awaited, stand over to 30th June.
Lords, learned advocate.
I take notice on behalf of the
I'll serve a
corporation.
copy on her, my lord. I'll serve a copy, my lord.
30th June.
Lords, these matters.
Long delay is there. 524 days.
Pardon, my lord?
Delay of 524 days.
Please, my lord, this matter is connected to those contempts, my lord, where we have carried out substantial compliances, my lord. The issue regarding the deemed regularization is involved, my lord. In
Deemed
all these
regularization,
matters.
we filed contempt, my lords, after issuance of notice in the contempt. Same matters, my
Same
lord.
matter,
Their
my lord.
contempts are all connected contempt.
All
petitions.
contempts are now connected, my lord.
Where I am appearing for the complainants.
Can be heard and decided, my lord, on this.
Lords, in respect of lords, there are about 6 to 7 petitions. In respect of all the petitioners, they have complied also. In fact, the respondent corporation is not even filed appeal. Lord, the state, in respect of only 2 or 3 persons, is taking a peculiar stand and saying that we are not. Therefore, my lords, on the face of it, there is violation of Article 14. In respect of the very same petition, few of the petitioners, they have complied. They have extended the benefit of regularization. And my lords, when
Certain reopening, whenever you want.
lords, any short date, my lords, so that because my lords, some of
18th June.
Very well. We will argue on that day, my lord, even on the delay as well as on the main matter.
86, 87 are urgent.
Number 19th, my lord. 20th. 18th, I have all the matters.
she is requesting for 20th, my lords, my lord.
20.
Very well. Lords, can I request for 2:30, my lords, if it is.
On that day.
Lords, what has happened, my lords? Few of them are attained superannuation, my lords. They are not even getting any benefits, my lords. Not even a single penny, my lords. They are getting very difficult for their survival, my lords. Grateful, my lords. Deeply okay.
Seal number 88, the furnishing of process fee, etc. for service of notice. 88, Mr. Chandra Govindraya Kamath.
Learned advocate for the 88. for the petitioner to take necessary steps. To be listed next, it shall be listed next on 30th June.
So number 89. Nandita D. Aldipur.
Appear for the appellant in the matters. In some of the matters, I have taken steps through hand summons. So those have been served. I have filed the memos in 89.1. I have served through hand summons on R1.
Lords, I undertake to file wakalat for R1 in 89.1. Lords, I request that a date may be fixed.
Thereafter in 89.11.
Lords, post vacation.
First, 2nd July.
Please.
2nd July. To be listed
Please.
on 2nd July. In the meantime, the learned advocates who may be appearing pursuant to the service of notice to respondents may file their respective wakalatnama as well as pleadings if required.
Please.
My Lordship,
Your Lordship.
I'm appearing on behalf of Srimati Sweta Anand, who's Wasilia. So we have complied with this thing. Memos we have put up, but it's not come before this honorable court.
The hand summons has been served on in some of the cases. If I can give the list to, it may be taken as served.
So 90.
Number 90.
90, I beg to appear for appellant, my lord. My lord,
The office of justice, dealing with the appeal shall stand dismissed.
I beg to appear for appellant, my lord.
Yes, next.
Number 91. Office objection with counsel submission.
May I audible, my lord, in serial number 90, my lord.
So 91, 92, 90, 91 and 92. Office of justice are dispensed with at this stage to be dealt with at a subsequent point of time if needed. Registry shall list the contempt petition on 11th June and 12th June, 11th June.
93,
91.
93, my lord, R5 and R6, my lord, notice has to be issued. 93, my lord, R5 and R6 notice has to be issued. R2, my lord, R2, R3 and R4 have filed their wakalat.
So what is to be done?
R5 and R6.
Shankarpuram residence.
Number 5.
Notice after hearing.
My Lord, I'll take notice for respondent number 5. It's the Commissioner of Police.
Without hearing, how can we?
Go ahead.
Number 94.
My lord, serial number 92. My lord, there are two office objections raised, my lords. My lord,
92. Yes.
My lord, the council
Lord,
submission may be
90,
accepted.
96, 97. Lord, these are two writ appeals filed by the Director General of Civil Aviation. Lord, the issue was.
96, I appear for respondent number 1. I have filed a caveat, my lords, on 6th of January, and I have also
Anyway,
intimated.
it doesn't
my
matter. Lord, the writ
office have not
petitioner
been served.
operates a microlight
Contempt
aircraft.
also has been
The
filed, and
DGCA
maybe connected
rules
along.
do not permit taking any other people for joyride. There should be insurance. So when he applied for the renewal, we raised certain shortfalls. Learned single judge has quashed all those shortfalls, my lord, despite the law being very clear. And no, my lord, he has filed a contempt petition and he's going to the office of the DGCA regularly and threatening them.
No, that is wrong, my lords.
Lord, he does not have insurance.
Cannot be
He's
made.
taking,
My lords, I'll
he's
file my
taking people on
objection, my lords.
joyride.
That is the. I'll
It's a
file my
fresh matter,
objection.
Lord, but there was some.
They have not filed their.
Some
They have not
unscientific
complied with their office objection.
office objection. It may be overruled and it may be taken up day after tomorrow or on 25th.
Office objection are overruled. The
My lords,
appeal may be listed on 26.
26. Well, I'm grateful.
My lords, the copies may be served, my lords.
It is 1 or 2, Mr. Kamal? 2.
Both 26, 97. Both.
My lords,
96 and
96, I
97
appear
same.
for R1. Copies may be served to me.
95.
Lord, serial number
95.
90.
The office objection regarding two different dates and same petition, the two different dates orders are
They are dispensed with.
Please, Lord. That has to be overruled, Lord.
Date may be fixed, my lord, in the same matter. For respondent number 1, my lord.
Date will be.
What has happened, my lord, there is an order.
3rd of June.
My lord, the issue is, there is an order stating them not to publish a particular list in serial number 95. In spite of there being an order specifically indicating them not to publish, they have gone ahead and published over and again, violating the order of the court continuously. That is why the court suo moto took up, initiated contempt.
This honorable court, division bench has
And
changed that order.
we were not heard in that matter, my lord. And after for almost 6 months, more than 6 months, my lord, they have not complied and it has been coming. I'm requesting that before the court goes on vacation, my lord, a date may be fixed.
When we will take up, we will be heard. Now 90, go on 80, 97, 90, 97 is over. 98.
My lord, serial number 92.
96, my lords, the
Notice may
copy
be
is-
They have gone now.
Notice
Yes.
may be issued, my
They
lord.
have gone. No notice can be issued in office objection.
My lords, the office objection may be overruled, my lords.
It is overruled.
Serial number 98.
Whatever it is, you remove or order is passed.
Serial number 98. Respondents have filed objection statement before in the writ petition side, my lord. They have produced the photographs. Therefore, my lord, therefore I am not able to produce the original photographs, my lord. That may kindly be, office objection may kindly be.
98 office objection regarding color photograph is dispensed.
Serial number 90, my lord.
98 date.
Filing matter, serial number 99. Mr. Vasant
Education
Aditya.
matter.
Appear for the
Date may
petitioner
be
in this
given.
matter, 29. I have instructions that a senior counsel has been engaged, may be listed after vacation.
99
99.
after vacation. 24th of July.
What's up?
98 date may be given, my lord. Education
100.
matter.
Anil Kembavi.
98 education matter, my lord. Date may be given.
No, call out 100.
100.
Appear for appellant
Will complete the board.
in the after
Is
vacation.
there? Call out, call out.
Serial number 100.
Appear for appellant in the after vacation. After having a vacation.
Which one?
100.
100.
Appear.
All right, when do you want?
After vacation immediately.
12th of June?
Yes.
12th of June or little later? 16th of June.
Yes. Much.
The serial number 94.
Serial number
Any relief is
98,
there?
my lord.
ಆಯ್ತಲ್ಲ ನಿಮ್ದು
Date ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡುದಿಲ್ಲ ಅವರು.
Any relief is there?
Sorry, my lord. Serial number 98, education matter. Date may be given, my lord. Education matter,
Which one?
98, my lord.
98 is gone now.
And
101.
date,
No, we are progressing with the board. Yes,
Serial number 101. Mr. MC Basuraj. It's a filing matter.
Give in somewhere in July, 27th July.
Serial number 102. So filing matter. Mr. Srinivas K.
28th July.
Respondent.
my lord, correspondent, my lord, for final hearing.
Serial number 94, my lord.
94.
94. But there is an office objection, my lord. Why the appellant is not made a party? That may be overruled, my lord.
I think we overruled.
That has to be overruled
Dispense.
after vacation.
It is dispensed.
My lord, with kind permission, my lord, serial number 90, my lord. My lord, I seek liberty to move it before vacation, my lord, after compliance of office objection, my lord.
Let you go before learner vacation, not before us.
Date was fixed, my lord, that's fine.
You go before learner vacation, not before us.
Date was fixed, my lord, that's fine.